Please, Your Lordships. My
Yes,
Lord, I beg to mention item 8. May I beg to mention item 8?
yes.
Kindly allow me to file my affidavit since it is under preparation.
You
After
are for the respondent.
I'm for the state respondents.
Okay,
I may be granted 2 weeks' time.
okay. Mister, your name, please.
My Lord.
Your name, please.
I'm LD Sanktam, additional AG.
Additional lazy for the state respondent. You inform the other side.
Petitioner is represented by P. Suren. I'm for the state respondents. Number
No,
2,
no,
3,
the,
4, 5, and 6.
The procedure is that you have to obtain consent from the other side
Yes, ma'am.
whenever you are praying for an adjournment.
Yes.
You have not informed the other side.
He's not outstation.
Maybe.
He's not from Kohima.
Maybe. You can inform him over phone also.
Yes, ma'am.
So you want 2 weeks time.
Yes, ma'am. To file my.
But you see, this is okay. On the pair being made by Mr. So learned additional lazy. This matter stands adjourned to be listed after 2 weeks. So as to enable him to file the affidavit in opposition.
Yes, ma'am.
Pair alert. Yes.
My
Any other
Lord,
matter?
even item 9 also, I'm yet to receive instructions. Item 9.
Lordships, for the petitioners in item 9, Lordship,
Yes.
I would object to that, Lordship, because here the state is a performer respondent only, Lordship.
Okay.
Yes, the petitioner is seeking action against petition number 2 and 1, 2 and respondent number 7, Lordship. This is urgent intervention is required from this honorable court, Lordship. So I beg that this matter may be taken up today, Lordship. We are just seeking a simple prayer, Lordship. We want to insist on submission of the status report, Lordship, of the road project. Lordship, as the petition is very clear, simply very clear, lead down prima facie, Lordship, and causing inordinate delay by respondent number 7, who is the contractor of NHIDC, Lordship. This is pertaining to 2-lane road, Kohima Jesami Road, Lordship. It's just a stretch of 21.90 kilometers, Lordship. However, it is.
Madam, you see,
Lordship, yes.
the question is, can we hear this matter without the affidavit of the state respondent?
Lordship, if they want to file, it is up to them. But like as I submitted, they're just performer respondents, Lordship.
Performer respondent.
Yes, Lordships.
Who's the main respondent?
Main respondent is NHIDCL and respondent number 7, who is the contractor, Lordship. Lordship, in fact, the timeline given for completion of this road project is 24th of September 2026, Lordship.
Okay.
Already they have exhausted, they could not meet the timeline also. EOT extension of timeline was granted by NHIDCL, given a strict direction that the work should be completed by 24th September 2026. Lordship, petitioners have also visited, Lordship, and also Students' Union has also visited. And the work progress is still showing a very poor progress, Lordship. As on 14 May 2026 this year, Lordship, as per the presentation given by the contractor, the physical work progress is showing only at 41.28%, Lordship. So, Lordship, since the people are suffering, Lordship, this is why the petitioners are compelled to approach this honorable court, Lordship, as this court has been.
We'll call the matter.
Lordship, yes. Please, Lordship.
Okay.
Obliged, Lordship.
Members, my lordships.
Yes.
Lordships, I beg to mention item 19. I'm for the appellant. Lordships, my senior has some difficulties today, so it will come up after 2 weeks.
Mr. Sikhu Patel, learned counsel for the appellant. Press for listing the matter after 2 weeks. as conducting counsel Mr. Lima Wapang.
Limapa, yes.
He's out of station.
No, Lordship, he has some difficulties today.
He has some difficulties today. Fair allowed, recessal is the matter. This is jail appeal. We'll fix it.
Yes, Lordship. After 2 weeks, first week of September, maybe. 9th.
September 9th.
9th.
Okay,
Lordship.
all right. September 9th.
Lordship, so also item number 20, I mentioned on behalf of the leading counsel, Mr. Taliao.
Hmm.
Lordship, let this matter come up for 3 weeks, Lordship.
On what ground?
Lordship, he's not keeping very well, Lordship. He's an
Okay.
outstation lawyer.
Mr. Prosiko Patel, learned counsel for the appellant. Press for listing the matter after
3 weeks, my lord.
3 weeks as conducting counsel Mr. Taliao is indisposed of. Here allowed, recessal is the matter after 3 weeks.
Hello, my son.
Also, I beg to mention item number 11. I'm for the appellate. So this matter will be, this is next week.
Why?
I have some personal problem.
Difficulties.
Yes.
Mr.
My lord.
I am so.
My lord, with due respect to my learned Advocate General, Lordship, Additional Advocate General, Lordship, this IA is for continuation of the case
Yes.
of 227 days. Now, after coming for motion, Lordship, they have sought time to file additional affidavit for 2 or 3 occasions. Now, after filing the additional affidavit, Lordship, they have sought time again to rectify the additional affidavit. My lady will know how much this matter has come up before this honorable court. Now, today also they are seeking time. The state has all the resources as a litigant, but for the private litigant, this is how they are using this court, Lordship. So as a private litigant, Lordship, there is enormous, Lordship, hardship, Lordship. So this matter may be taken up, Lordship. This is my humble prayer, Lordship.
Next state, I'm not seeking for the further time. Of course, I admit I have taken several times, and this may be the last time because today I am not in a position to take up this matter.
Okay, let it be on 3rd of September then.
Lordship,
Next
I am in bereavement, but still I came. Yesterday my uncle died, but then for this matter, I've
No,
come.
you see, if he is not ready to argue the matter, what to do?
Enough time has been given to
I
them. Lordship.
admit, but today I have some difficulties.
Okay, on 3rd of September, we'll dispose of this matter.
Yes.
Yes, Lordship. It's up to you, Lordship.
As agreed by learned advocates of both the parties, recessal is the matter on 3rd of September, and on that day, an endeavor will be made to finally hear and dispose of this application.
Lordship. Obliged, Lordship.
May I please, Your Lordship?
Yes.
My lord, I beg to mention item number 25. My lord, I've taken consent from the opposite party. Let the matter be taken up next week, my lord. It's our consensus prayer, my lord. I have no objection, Lordship.
Okay, as agreed by learned advocates of both the parties, recessal is the matter on 3rd of September.
Yes.
3rd of September.
Obliged, Lordship. Much obliged.
May I please, Lordships. My lord, I beg to mention item number 17, my lord. Here, my lord, my senior Ajo, he has been appointed as amicus curiae, my lord. But my lord, today he could not able to come because he has been suffering from seasonal flu and cough for a few days. So I pray that, my lord, 3 weeks time may be given, my lord.
Mr. Your name, please?
B. Soto, my lord.
Learned counsel
For the
for the
appellant,
appellant.
my lord.
With concern from the other side, first for listing the matter on
After 3 weeks, my lord.
after 3 weeks.
My lord, after 3
After
weeks.
3 weeks, as conducting counsel, Mr. Azo has some difficulties today. Fair allowed, recessal is the matter after 3 weeks. And in respect of item number 16,
Item number
Yes,
16,
Mr.
yes, my lord, I
Gohati.
have the same prayer, my lord.
but you see, this appeal is of 2019.
Yes, my lord.
So a lot of adjournment have been granted. The problem is it is of 2019. There is everything that they. Easily on his completion is there. Completion statement is not recorded in the proper form. Like how reflection of that video.
Can he come next week?
In this coming 2 weeks, we have a few fixed matters in the division bench. So I pray after 2 weeks, my lord.
No, you see this appeal is of 2019.
Yes, my lord. Yes, my lord.
So if here also Mr. Zoe is
Yes, yes.
amicus.
No. In item 6 to this is not an amicus, my lord.
He is engaged counsel.
Yes. He's private counsel, my lord.
Okay. Okay. On the appearing made by Mr. So learned counsel. Appearing on behalf of Mr. Azon, learned conducting counsel for the appellant, this matter is then adjourned to be listed after 2 weeks.
2 weeks.
We will fix it at that. On 9th of September. 9th
My
of
lord, my
September.
lord.
Lordship, in the cost list, PP is Mr. K. Authorised is no more, so that the name may be deleted from the cost list. And I'm appearing on behalf of the state as a prosecutor.
In item number 16.
16.
Okay. And heard Mr. Im Sung, learned. You are appearing as PP.
PP.
Learned PP. Authorized respondent. And he submits that Mr. KK Watsa.
KK Watsa.
He suffered demise.
No, he's no more. He left the Benton. He's no more with the government
Okay.
No, he's passed away.
and also
He's
expired.
passed away.
Okay. As passed away. And as such, he submits that the name of Mr. KK Watsa may be struck off from the cause list. Here allowed. Okay.
Much obliged.
Please, your lordships, I beg to mention item 7, your lordship. Your lordship, here, I've sent the affidavit for vetting. So this matter may kindly come up next week, your lordship.
Item
Items-
number 7.
Yes, your lordship.
You inform the other side?
No, your lordship.
Not informed. Ms. Levika, learned government advocate appearing for the state respondent. Press for listing the matter in the next week. So as to enable her to file the counter affidavit. Fair allowed, list the matter on 3rd of September. And Ms. Levika shall also produce the relevant file before this court on that day.
Oblige, your lordship.
May I please, your lordship? Lordship, I beg to mention item number 21 and 22, lordship. Lordship, here my senior will be arguing this case, lordship. Today he has some personal difficulties. So if this matter may be listed next week, lordship, on 2nd.
2nd or 3rd?
Second.
Second is Wednesday.
2nd is Wednesday.
Second is Wednesday, my.
Okay. On the pair being made by Ms. Esther, learned counsel for the appellant. This 2 matters, item number 21 and 22,
Yes, my lord.
stands adjourned to be listed in the next week
Lordship.
on 2nd of September.
Yes, my lord.
Where allowed, recessal list is 2 matters on 2nd of September.
Much obliged, much.
Please, my lord, I'd like to mention item number 12. Lordship, here I have instructions to appear. So if some time may be granted to me for filing of.
For the opposite party,
Respondent number 5, my lord.
Respondent number 5. Mr. So-and-so, learned counsel, appearing for respondent number 4, submits that he has the instruction to appear on behalf of respondent number 4.
I'm so sorry, lordship. My sincere apologies. Respondent number 1.
Respondent number 1, okay. You have filed your Kalatnama?
Lordship, no. I seek some time to file a vakalat as also an
And
affidavit.
price
counter
for-
affidavit, so advised. So advised.
Price for granting him some time to file his power and also the affidavit in objection, also objection. Mr.
Your lordships, the leading counsel is appearing through VC.
Yes,
Appearing
Mr.
for-
Litigants.
Lordship, I am appearing for NHIDCL appellant, madam,
Okay,
assisted by Mohajamil.
Mr. P.J. Soikia, learned senior counsel, assisted by Mr.
Mohajamil.
Wazami. Is present for the
Appellants.
appellants. No, for the applicants here,
Applicants.
yet to be admitted.
Yes, lordship.
We are allowed to list the matter in the next week,
Lordship, I seek 3 weeks time. 3 weeks time.
3 weeks.
Yes, lordship, for filing a vakalat as well as a counter affidavit. Is so advised.
Yes, Mr. Soikia, any objection?
Let me in the 4th week in that case, madam,
4th week of September.
Lordship. Preferably Thursday, perhaps. But
Thursday.
I
24th
think
September then
DVC, it's only on Thursday. I will be there only.
Only on Wednesdays.
Wednesday.
Wednesday, sorry, madam, sorry.
On 23rd
Yes.
then
23rd. Madam, can it be on 30th September, 30?
okay, no problem.
Obliged.
Yes, yes.
I'm obliged, madam.
May it please lordships,
Mm.
I beg to mention hearing item number 24. The arguing counsel is indisposed. I pray that this matter may be listed after 3 weeks.
Miss, your name please?
Menoshano,
Learned counsel appearing on behalf of Mr.
El Iralo.
L. Iralo, learned conducting counsel for the petitioner submits that conducting counsel Mr. L. Iralo is indisposed of and she plays for listing the matter when
After 3 weeks.
after 3 weeks. Fair allowed.
Obliged. May I please your lordships? I beg to mention item number 9. Lordship, I'm appearing on behalf of my senior for respondent number 2. We have filed our Wakalatnama. Lordship, we are
No, we'll call the matter. Someone has mentioned the matter.
like.
We'll call the matter.
Just wait, we will call out
Okay, okay.
when the
Lordship,
matter
I-
reaches.
Okay, then I beg to mention item number 10. Service upon respondent number 3, 4, and 5 is completed, your lordships. I pray that the matter be listed after 3 weeks.
Then
Part Miss so-and-so, learned counsel for the appellant. And Mr. I. Imsung, learned additional legis for the state respondent.
May it please your lordship. Your lordship, I have an instruction to appear on behalf of respondent 4 and 5, lordship.
And Mr. Your name?
Tushitam Jai.
Learned counsel. For the respondent number 4 and 5.
Yes.
The learned counsel for the petitioner submits that in this matter service is completed. And as such, the matter may be listed for hearing. Fair allowed, list the matter after 3 weeks.
3 weeks, yes.
Process.
Much.
Lordship, I beg to mention item number 23. My senior is indisposed. Kindly list the matter after 3 weeks.
Who is your senior?
Cindy Younger.
Ms. So learned counsel appearing on behalf of Mr. Santi Engar, learned conducting counsel for the appellant. Price for listing the matter when?
After 3 weeks.
After 3 weeks. Fair allowed, rest is list the matter after 3 weeks.
Much obliged.
For motion, item number 1.
Mr. Lordships. Lordship, here, the petitioner is praying for setting aside and quashing the impending detention order passed by the district magistrate Kohima, dated 3rd July 2026, and impugn approval order dated 14 July 2026. Lordship, here, there are 3 detained persons here in this case, Lordship. Means 3 persons that were from the same FIR, so I've filing 1 petition, Lordship. Lordship, here the brief fact of the case is that on 18/6/2026, Lordship, the detainee number 2 and 3 came to Kohima from Dimapur to drop off the detainee number 1. However, and they had a lunch from town area, and while they were resting in Fiso Cemetery at near New Secretariat, the police personnel came and they were taken away to the North PS. And after that, they were shown arrested, Lordship, on 18/6/2026, Lordship. And thereafter, on 19/6/2026, they were produced before the Honorable CJM Court, and where 5 days judicial remand were sought by the IO. And after the expiry of such remand on 3rd July 2026, the district magistrate has passed the detention order, followed by approval order dated 14 July 2026.
So what are the ground?
Lordship, my ground is at page 15, Lordship, starting from page 14, Lordship. Here, there is a gross violation of section 10 and 11 of the State Act, Lordship. Here the respondent
10 and 11.
Lordship.
10 and 11.
Yes, Lordship. Here, the respondent number 1 has disposed of the representation, Lordship, without referring it to the advisory board, Lordship. Without referring it to the advisory board, Lordship. Lordship, here, the competent authority to dispose of the representation as per section 10 and 11 is the competent authority is the advisory board, Lordship.
Competent authority is?
Advisory board, Lordship.
Advisory board.
Yes, Lordship. And Lordship, despite even after a lapse of 3 weeks, Lordship.
What is the period within which the state has to forward the matter to the advisory board?
The detention order was passed on 3/7/2026, Lordship. So the mandatory period is 3 weeks.
3 weeks.
Yes, Lordship, to place the grounds.
The 3 weeks period is over now.
Yes, Lordship. 3 weeks is the 3 weeks to place the grounds on which the order has been made, Lordship, to the advisory board, Lordship. Lordship, and the other ground is that there is no mention in the detention order, as well as in the schedule and in the ground of detention, that the detainee are under judicial custody, Lordship, and is the likelihood of them being released on bail, Lordship. Lordship, these are my 2 main grounds, Lordship.
Okay. Yes, Madam, any instruction why the matter has not been referred to the advisory board?
No, Your Lordship, I don't have the instructions with me, so notice may be issued, Your Lordship. I'm representing.
Who is appearing for Union of India? You.
Yes. Lordship, here I have submitted my representation on 13/7/2026, Lordship. However, there is no response from the Union of India, Lordship.
Okay. Heard, Mr.
Mr. Lordship.
Learned counsel for the petitioner, Ms. Levika, for the respondent number 1, 2, 4. 1, 2, 3. And Mr.
I'm Ina Holly, Your Lordship, and I'm presenting 120.
Oh, Ina Hole, okay.
Yes, sir.
Okay, sorry. Ina Hole, learned counsel for the learned government advocate for the respondent number 123.
123, Your Lordship.
And Mr.
That can only Malam, CGC.
Learned CGC for the respondent number 4. In this petition under Article 226 of the Constitution of India, 3 petitioners, namely Sri Senlo King, Sri Kito Ace Zimomi, and Sri Tobito Kiba, has challenged the order dated detention order dated 3rd of July 2026 and the approval order dated 14/7/2026. 2026. Mr. So-and-so learned counsel for the petitioner submits that this petition is prepared by the petitioners for contravention of the provision of section 10 and 11 and any other section apart from 10 and 11
Section 14A, Lordship.
and
Also there.
section 14A of the National Security Act. National Security Act. National Security. The submission of learned counsel for the petitioner needs further consideration at this stage. Notice be issued to the respondent. Returnable. When?
Your Lordship, after 3 weeks, Your Lordship.
Lordship.
No.
This will
Have
2
you
weeks
scored?
corpus. This is this habeas corpus, Lordship.
After 2 weeks. We'll fix the date. Suggest the date after 2 weeks.
September, Lordship.
9th of September.
Yes, Lordship.
9th of September. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. However, extra requisite copy of the petition may be furnished to them during the course of the day. On the date fixed, the learned counsel representing respondent number 1, 2, and 3 shall produce the relevant file and may also file the affidavit in opposition if so advised. Union of India want to file the affidavit? Yeah?
Yes, my lord. So that only 2 weeks time is a very short period, my lord.
Oh no, this is habeas corpus.
No.
On 9th of September.
Bless your heart.
From the supplementary cause list for motion item number 26.
Please, Lordship.
Yes.
Lordship, this petition is directed against the order dated 25/6/2026 passed by the Central Administrative Tribunal Gauhati bench, by which the learned tribunal has dismissed the application filed by the petitioner, which is OA 046/249 of 2024, Your Lordship. Now, the subject matter relates to appointment by promotion to the Indian Administrative Service, IAS, of members belonging to the State Civil Service, Your Lordship. Now, petitioner, she has been already appointed to the IAS and she has also retired, Your Lordship. But the grievance of the petitioner, Your Lordship, relates to the year of allotment, which year the IAS allotted, because, Your Lordship, that year of allotment, it determines the seniority, her seniority in the IAS cadre, and which also has consequential benefits, Your Lordship. So that is the grievance, Your Lordship. Now, Your Lordship, appointment by promotion to the Indian Administrative Service, Your Lordship,
Mm.
of members belonging to state civil service is governed by
Mm.
the IS Recruitment Rules 1954
Mm.
and the regulation frames thereunder, Your Lordship.
Mm.
And
Mm.
that is the regulation, the IS appointment by promotion regulation
Mm.
of 1955, Your Lordship.
Mhm.
Now, may I take Your Lordship to the regulation, Your Lordship?
Okay.
The rules and the regulation. Rules, regulation. May I first take Your Lordship to the rules.
Mm.
Definition of state civil service, which is at Rule 2G.
Mm.
Lordship has got it?
Got it.
Rule 2G. State civil service means two will be relevant. Next page, Your Lordship. In all cases, in all other cases, any service or services approved for the purpose of these rules by the central government in consultation with the state government, a member of which normally holds charge of a subdivision of it. The member must be holding a charge. That is what I would like to impress upon Your Lordship. So he or she is a member of the state civil service. Next, Your Lordship, Rule 4. Method of recruitment. B, Your Lordship, by promotion of a substantive member of a state civil service. Lordship has got it?
Got it.
Now, next will be the last one, Rule 8.1. Lordship has got it? Rule 8.1. The central government may, on the recommendation of the state government concerned and in consultation with the commission, that is the UPSC, and in accordance with such regulation as the central government may, after consultation with the state government and the commission, from time to time, make recruit to the service persons by promotion from amongst the substantive members of a state civil service, Your Lordship. Now, what I would like to impress upon Your Lordship is that the member must be holding a substantive post, Your Lordship. Now, in terms of Rule 8.1, Your Lordship, regulation has been framed. May I now take Your Lordship to the regulation of 1955.
Yes.
Regulation 3, Your Lordship. Regulation 3, I need not read out the whole. Interesting, the provision. It provides for constitution of selection committee, Lordship. And regulation 5.1, may I read out?
Yes.
Each committee shall ordinarily meet every year and prepare a list of such members of the state civil service as are held by them to be suitable for promotion to the service. So the number of members of the state civil service to be included in the list shall be determined by the central government in consultation with the state government concerned and shall not exceed the number of substantive vacancies. That is, the select list should not exceed the number of substantive vacancies as on the first day of January of the year in which the meeting is held in the post available for them under Rule 9 of the recruitment rules. The date and venue of the meeting of the commission to make the selection shall be determined by the commission. May I take Your Lordship to 5.2.
Yes.
5.2 provides for the ratio. The committee shall consider for inclusion to the set list the cases of members of the state civil service in the order of a seniority in that service of a number which is equal to 3 times the number referred to in sub-regulation 1. That is, Your Lordship, 3:1. For one post, 3 members, Your Lordship. Now, regulation 6. So, regulation 6, Your Lordship.
Yes.
It provides that the select list
shall be this list prepared in accordance with Regulation 5, that is the select list, shall then be forwarded to the Commission by the state government along with the record of all members of the state civil service included in the list, and 4, the observation of the state government on the recommendation of the committee. Your Lordship, now may I take your Lordship to Regulation 7. The Commission shall consider the list prepared by the committee along with the documents received, etc. And 7.3. Next page. The list as finally approved by the Commission shall form the select list of the member of the state civil service. So these are the provisions which governs the appointment by promotion to the IAS of members belonging to the state civil service. Now, may I take your Lordship now to my plea petition, your Lordship. Page 56. Page 56.
Yes.
Yes. Now, as provided under the regulation, your Lordship, the selection committee was constituted, and this is the minutes of the meeting of the selection committee. May I read out? Minutes of the meeting of the selection committee constituted under Regulation 3 of the Indian Administrative Service Appointment by Promotion Regulation 1955. I'll just refer to regulation. To prepare select list of 2020. This is relevant, your Lordship. Select list of 2020 of such member of the State Civil Service of Nagaland who are suitable for promotion to the IAS against the vacancy of 2020, your Lordship. And next para, the selection committee, it met on 7th December 2021. This date also is relevant, your Lordship. Now, may I take your Lordship to para 3.2. Next page, 57. The committee will also inform that the maximum number of state civil service officers who have been included in the selection is 6 against 6 vacancies. So there are 6 vacancies, your Lordship. In the promotion quota of the state cadre as determined by the central government in terms of rules and the regulation. Number of eligible officers to be considered by the committee shall be equal to 3 times the number of vacancy, which is, your Lordship, is 18. 3:1 against 6 vacancy. Now, may I take your Lordship to page 67? This is part of the minutes, your Lordship.
Yes.
So this is the assessment for the select list of 2020. Your Lordship, for convenience, I'll differentiate, I'll refer to it as assessment list. This is the assessment list. Based on this assessment list, select list is prepared, your Lordship. Now, in this assessment list, your Lordship, the name of the petitioner appears as serial number 7. Lordship has got it?
Got it.
Now, may I? Now, based on this, your Lordship, page number 63.
Yes.
Para 6.2. So, based on this, based on the assessment list, your Lordship, this is the final select list. On the basis of the above assessment, that is the assessment list, the committee selected the officers whose names are mentioned below. So this is the final select list of the committee, your Lordship. Now, the name appear from 1 to 6 is in the assessment list. It also appears from serial number 1 to 6, your Lordship. Yeah, because the name of the petitioner is placed at serial number 7, your Lordship. Now, your Lordship may kindly recollect the selection committee met on 7th December. May I take your Lordship to page 69?
Yes.
Page 69. Your Lordship, the last para. Further, it may be informed. Your Lordship has got it.
Got it.
Further, it may be informed that she such and such recommended for promotion at serial number 6 of the SCM expired on 29/11/2021. In fact, prior to meeting of the selection committee, Your Lordship, the member who is placed as serial number 6 has already expired. Your Lordship. Now, the grievance of the petitioner, Your Lordship, is that because of inclusion of the name of a deceased member in the select list, Your Lordship, the petitioner has been placed at serial number 7 instead of serial number 6. That is the grievance, Your Lordship. Now, Your Lordship may kindly come to notification, the page 76. This is the final notification issued by the Ministry of Department of Personnel and Training, DOPT. Lordship has got it. Only 5 of them they have been appointed to the IAS from the select list. Though 6 were recommended, and the fact that only 5 of them speaks for itself that a deceased member cannot be appointed. Lordship. So the main grievance of the petitioner, Your Lordship, is that inclusion of the name of a member in serial number 6, a deceased member, Your Lordship, in the assessment list and also in the select list for the year 2020 has caused prejudice to the petitioner, Your Lordship, and thereby arbitrarily and illegally denied her the right to be considered for appointment to the IAS as per the select list of 2021. Your Lordship, as I've said, petitioner has been already appointed, but appointed against the select list of 2021. That way, she lost 1 year seniority, Your Lordship. Now, however, Your Lordship, the learned tribunal rejected the plea of the petitioner on the ground that reflected the name of a deceased member is consistent with the statutory provision. Your Lordship. May I take Your Lordship to page 39? This is the order in order. Page 39. This order dated 25/6/2026, page 40. Relevant para, Your Lordship, para 17, page 53.
Yes.
On the zone of consideration contention, the applicant further contention that the 6th vacancy of the select list 2020 ought to have been devolved upon her consequent on the death of such and such prior to the selection committee meeting on such and such is also without merit. The 1955 regulation contains no provision for excluding a deceased member or retired officer from the zone of consideration or from the select list as recommended by the selection committee. The select list published in such and such is consistent with the statutory provision, Your Lordship. Now, in my respectful submission, Your Lordship, the finding of the learned tribunal is perverse and contrary to the rules and the regulation because, Your Lordship, as per the rules and Your Lordship, the definition, member of state civil service means person who is holding a substantive post, Your Lordship. Now, a person who is no more, deceased member cannot be said to be holding a substantive post, Your Lordship. Now, therefore, Your Lordship, this finding of the learned tribunal in my respectful submission, Your Lordship, is perverse and in fact it's contrary to the rules and regulation, Your Lordship. Now, my ground for challenge, Your Lordship, page 26. Lordship has got it, page 26.
Yes.
Yes. A, for that inclusion of name of deceased member of the SCS of Nagaland, namely such and such, in the select list of 2020 by the committee is contrary to the provision of rules such and such and regulation 1955 for the following reason. As per rule, and the provision I've taken Your Lordship to that. I will not bother you. I'll not trouble Your Lordship. Now, mainly on rules, Your Lordship.
Hmm.
In fact, when the rule regulation establishes that person, a member of a still civil service must be holding a substantive post, Your Lordship.
Hmm.
Now, a deceased member, including the name of a deceased member in the select list, cannot, Your Lordship, cannot be said to be in conformity with the statutory rules and regulations, Your Lordship. Now, so my prayer, Your Lordship, I will not go to the other grounds, Your Lordship.
Not
But
necessary.
in fact, Your Lordship, at this stage, I have a petitioner is a prima facie. At this stage, Your Lordship, this notice may be issued, Your Lordship.
But the tribunal has rejected your petition on different ground.
Your Lordship?
The tribunal has rejected your petition on different ground.
No, but the finding, because that was one of my challenge, Your Lordship, and that is in fact, that is the best challenge, Your Lordship. Now, whether, and the issue involved in this petition, Your Lordship, whether a deceased member of the state civil service can be included in the select list and be recommended for appointment to the IS, Your Lordship. That is the issue involved in this petition, Your Lordship, which is purely a question of law.
So what is the year of allotment?
The year of allotment, Your Lordship, may I take? Now, here, Your Lordship, it's governed by the seniority rules are there. May I take Your Lordship to I have annexed the rules.
The tribunal has considered rule 3, sub-rule 3, Roman 2 of the 1987 rule.
Yeah, that is supposing if I'm if the year of allotment is 2021, Your Lordship. Now, for example, for those who are elevated from the bar, appointed from the bar as a judge, I'm informed that 10 years benefit is given for seniority, whatever, for pension, whatever. So similarly, Your Lordship, rule 3, page 192, Your Lordship, may come. The IS Regulation of Seniority Rules, 1987. So that is for calculation of the seniority, Your Lordship. But here I'm saying that will be my second step. Supposing if I'm allotted 2020, then my seniority counting from as per rule 3.2 of the seniority rules 1987, Your Lordship, my year of allotment will be 2021 because 9 years benefit will be given to 2011, Your Lordship. Yeah, that has been worked out. Chart is there, page 90, I think, if I'm not mistaken. Yes, page 90, chart is there, where the detailed picture is more elaborately explained. Section 3.2 of the Senate Rules 1987. Lordship has got it? Now, in the table below is given, completed years of qualifying service. That will be qualifying service will be, Your Lordship, in the rank of Deputy Collector. Deputy Collector, in the rank of Deputy Collector. So for 12 years service, minimum 3, 15, 18, the length of service, and 27 years, maximum 9. Now, though she has served for more than 27 years, like maximum weightage will be 9 years. That's seniority. Now, if she is allotted 2020, as per the select list of 2020, then her seniority will be counted with from 2011. You have 9 years. Benefit will be given. Now, since she has been included only in the select list of 2021, Your Lordship, her seniority is counted with effect from 2012, 9 years. So that way, consequential benefits, she's losing, Your Lordship. Now, 3.3 relates to seniority, determination, calculation of seniority, not whether a deceased member can be included in the select list. That is totally different aspect, Your Lordship. Now, the learned tribunal, the finding of the learned tribunal is that since 2021 is my year of allotment, the seniority should be, so 9 years, then my this thing weightage will be given. So my seniority in the IS category will be 2012, and that is correct. So that is not my case. My case is that I ought to have been considered in the select list of 2020. But because of inclusion of the name of a deceased member, Your Lordship, I am placed at serial number 7.
Or Mr. T.V. Zomer, Learned Counsel for the petition. Anybody for the state respondent?
I'll be accepting notice on behalf of Yanawari for the respondent number 1, Union of India.
Respondent number 1.
It should be 1 and 3, Your Lordship.
1 and 3. 1 and 3. And Madam?
Lordship, I'll be accepting notice on behalf of respondent number 2.
Respondent number 2. Respondent number 2. This petition under Article 226 stroke 227 of the Constitution of India, the petitioner has challenged the order dated 25th of June 2026 passed by the Learned Central Administrative Tribunal within bracket CAT Gauhati bench in OA number 046 stroke 00249 stroke 2024. And also to direct the respondent authorities to enter stroke 8 the name of the petitioner in the select list of 2020 at serial number 6 in place of Sri Imses and Jamir since deceased. And also to direct the respondent number 4 to include stroke 8 the name of the petitioner in the approved select list of 2020 at serial number 6 in place of Sri so-and-so. Since this is void dated 21st of January 2022 for filling up the vacancies of Nagaland cadre of IAS under SCS category. And also to direct the respondent number 1 and 3 to include stroke 8 the name of the petitioner in the notification F number 14015 stroke 16 stroke 2021 AIS I -A dated 25th of January 2022 at serial number 6 by deleting the name of Sri Imses and Jamir since this is. And also to direct the respondent number 1 and 3 to include stroke 8 the name of the petitioner in the notification F number 14015 16 stroke 2021 AIS within bracket I B dated 25th of January 2022 at serial number 6, by which the appointment of only 5 members of the SCS of Nagaland to the IS was notified against 6 vacancies with all consequential service benefits.
Yes.
And also to set aside the order dated 14014 stroke 05 stroke 2 2020 dash AIS dash 1 Roman 1 dated 14/6/2023 issued by the Department of Personnel and Training, whereby the year of allotment of the petitioner has been arbitrarily altered to 2012 from 2011 and to restore the seniority stroke year of allotment of the petitioner as per the earlier order dated 27/12/2022 issued by the Department of Personnel and Training, Government of India, with all consequential benefits. And also to direct the state respondent number 2 to revise restore the seniority of the petitioner in the civil list of IS officers of the Nagaland cadre as on 1/4/2024 by placing the petitioner below Sri Gregory Tejawali and above the private respondent number 5, 6, 7, 8 and 7 and 8 as per the civil list of IS officers of the Nagaland cadre on 1/1/2023. And further to direct the state respondent number 2 to grant selection grade in level 13 of the pay matrix to the petitioner with effect from 1/1/2024. Mr. Zamir, learned counsel for the petitioner, submits that the petitioner was serving in state civil service in the year 2020.
2020.
2020.
Seems she joined state civil service long back, Your Lordship, as EAC, Your Lordship. But her name was included in the select list for the year 2020, Your Lordship.
When she entered into the service.
Your Lordship. Your Lordship may kindly come to page 173. Page 1, the officer, Lordship has got it? IS officer, civil list information system, page 1, relevant page will be 177.
Her name is at serial number?
44. At that point in time, she was serving in column 4, Secretary Social Welfare. Column 4.
And her name was placed in the select list. No,
Your Lordship, initial appointment, Your Lordship, I think.
What?
Page 143.
143. 143.
on 15th of July 1991.
Lordship.
And at the time of consideration, she was serving as Secretary Social Welfare,
Lordship.
the government of Nagaland,
Lordship.
Government of Nagaland. And during the period 1/1/2020 to 31st of December 2020, 6 vacancies arisen for appointment by promotion to IS. And in that regard, a selection meeting was held on 7/12/2021. And the selection committee, so constituted by the Union Public Service Commission, within bracket hereinafter UPSC, has recommended 6 officers out of 18 suitable officers by including a deceased member, namely Sri Imsesen Zomir of the State Civil Service, who suffered demise on 29th of November 2021 at serial number 6 in the select list of 2020. And as the name of the petitioner was placed at serial number 7, the respondent authorities have not considered and recommended her name against the 6th vacancy. Mr. Zamir, learned counsel for the petitioner, submits that as per Rule 8 of the Rule of 1954, Rule of 1954, for being promoted to the IS, the officer must hold a substantive post in the state civil service. And since the person who has been placed at serial number 6 of the select list had already suffered demise, the commission would not to have placed his name in the select list. And being aggrieved, the petitioner has preferred, the petitioner has approached the Central Administrative Tribunal by filing one application number 046/00249 of 2024, but by the impugn order dated 25/6/2026, the tribunal has rejected the petition of the petitioner, and being aggrieved, the petitioner approached this court by filing the present petition under Article 226/227, seeking the reliefs as aforesaid. The submission of Mr. Zamir, learned counsel for the petitioner, needs further consideration. At this notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 4, 5, 6, 7, 8 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 2, and 3, since they are represented by their English counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. This is at least a matter of 4 weeks.
For authors, item number 9.
Please, Your Lordships.
Yes.
Lordships, I've received instruction to appear on behalf of private respondent number 7, that is a contractor. So kindly allow me a week's time to file my wakalat nama.
What about respondent 2? Who is representing respondent 2?
Lordship, earlier a lady was mentioning, but I don't know where she is now. But I was informed by that Sandy Younger will be representing them, Lordship. Lordship, in fact, we have taken steps on 21st of July 2026 and 23rd, Lordship. And Lordship, we are not seeking, the petitioners herein are not seeking any adverse orders against any respondents in this case. Rather, Lordship, they are only seeking, in public interest, Lordship, the effective, Lordship, and timely completion of the road project, Lordship. Lordship, one of the prayers among the 5 simple prayers made by the petitioners in this case, one is to kindly monitor, Lordship, the construction of this road project, Lordship, as this court has benevolently done in on its own motion with regard to Kohima, Dimapur Kohima foreign road as well, which is listed today, Lordship. So, Lordship, as I stated earlier also, Lordship, now the completion of, there are 5 packages in this sanctioned in this 2-lane road project, Lordship. It is called Kohima Jesami Road, Lordship. It's a project of Ministry of Road Transport and Highways, Lordship, implemented by NHIDCL, Lordship, who are all included as respondents, Lordship. Now, initially the project was sanctioned on the 11th of March 2020, Lordship, and project was letter of award was contract was awarded to MSKCPL. It was terminated on 17th of April 2023, Lordship, due to failure of meeting timelines, Lordship, by NHIDCL. Again, this road project was balanced for the balance work. The NIT was issued on 8th of May 2023, Lordship. Then respondent number 7 also participated, and on 10th of October 2023, letter of award was given to respondent number 7, Lordship. However, Lordship, the respondent number 7 failed to meet the timelines, Lordship. So on 19 August 2024, NHIDCL has terminated the contract, Lordship, on citing various grounds, Lordship, which I have already enclosed, Lordship, in my main petition, Lordship. Now, the NHIDCL stated that as on 17 of August 2024, the physical progress of the road construction stood only at 0.39%, Lordship, and they have not met the requirements, so contract was terminated, but contractors still continued. Lordship, I would like to reiterate that the petitioners are not concerned about whoever is executing the project. The only concern is that the project has to be completed on time. Why? Because, Lordship, this is serving as a lifeline, Lordship, to 3 districts, Lordship, 3 districts of Nagaland, also connecting 4 districts, Lordship, Kohima, Peg, Maluri, and Kifiri. Kohima, Peg, Maluri, and Kifiri are officially recognized as a socially and economically backward tribes of Nagaland, Lordship. So thousands of people are depending on this project for transportation of essential commodities, Lordship, for transportation of patients, Lordship, because mostly in this 3 districts, the health facilities are not up to the mark, Lordship. And also students with government servants, many others depend on this road, Lordship. Now, keeping in mind the urgency of having a good road, Lordship, MORD has sanctioned the project, Lordship. But the road was already bad. But after the coming of the road project, it has gone horrible, Lordship. And even the farmers are facing the brunt because if it rains, Lordship, it's not pliable, Lordship. Now they're stranded, and these poor farmers, their items that they do business is mostly perishable items, Lordship, and which is again dependent by the other citizens living in Dimapur, Kohima, and others, Lordship. So again, it pinches them also because sometimes they have to take the long detour, Lordship, if the road is blocked. Then it consumes time, and then they shell out extra few thousands of rupees, Lordship, again. Now, Lordship, the facts are very clear. NHIDCL has already terminated the contract, which they are continuing. We have no problem. Now,
It's terminated. You were saying that the contract of respondent 7 is terminated.
yes, Lordship.
Then how come they are still continuing?
We don't know, Lordship. But as we stated, we have nothing against the contractor. Our only prayer is that, in fact, the timeline given by NHIDCL is 4th of January 2026, this year, Lordship. But it was 263 days was extended, Lordship. And that is ending on 24th of September 2026, Lordship, which is hardly a month's time from now, Lordship. Now, petitioner said that not even 50% is still, is completed as on today also, Lordship. Now, at this rate, Lordship, I don't think justice will be done, Lordship. People will continue to suffer, Lordship. It is also about, Lordship, public funds, Lordship. Now, petitioners are extremely aggrieved and having apprehension out of concern for the citizens, Lordship. As I stated, it is 4 districts are connecting 4 districts. This road also connects Manipur, Lordship. It is an interstate road. It is also connecting. It is also an international road, Lordship. It connects Myanmar and also has potential of boosting the economy of the nation, Lordship. Now, at this rate, Lordship.
No, that's all right. But you see, all the parties are not before the court today.
Lordship, yes, I agree, Lordship. I agree. So, Lordship, in the interim, Lordship, if on the next date, if they want to file their affidavit, it's okay. We have nothing, Lordship. But at least to ensure that, Lordship, some progress is there, some actions are taken, Lordship, by the contractor. I'm not pressing for adverse order against any of the parties here today. I'm only praying that on the next date, status report be submitted by NHIDCL and the contractor, Lordship.
Okay. Who is appearing for NHIDCL? You.
May I please to Lordships. Lordships, I am appearing on behalf of my seniors and the younger for respondent number 2, Lordships. So, Lordship, we have not received any instructions so far, Lordship.
Okay, you obtain instruction and file one status report before this court on next date.
Lordship.
We'll fix the matter after 2 weeks.
Lordship, yes.
In the meantime, you may file your Ukalatnama. And you are Mr. Sanctum.
Yes, my lord, I'm for state respondent number 3, 4, 5, and 6.
3, 4, 5, and 6.
Yes, ma'am. Here, my lord, the main respondents are respondent number 1, 2, and 7.
Yes.
We are only a supervisory agent.
Lordship, yes.
Okay.
Yes, ma'am.
Pardon, miss, your name, please?
Nitya Lordship.
Learned counsel for the petitioner. And Mr. Sanctum, learned additional lazy for the respondent number 3, 4, 5, and 6. And madam, your name, please?
Grace.
Learned counsel for the respondent number 7. And Mr.
Noklayam Konyak for respondent number 2.
Learned counsel appearing for respondent number 1 and 2. Not 1.
Not 1, Lordship.
Respondent number 2. None appears for the respondent number 1. Whether notice was served up.
Lordship, yes. As directed by the court, we have given copies, Lordship.
None appears for the respondent number 1, though notice upon respondent number 1 was served by. How you effect the service upon respondent number?
Lordship, in the order, Lordship, it was only written we give copies, Lordship. So we have given them, Lordship.
Okay.
To the CGC, Lordship.
CGC.
CGC, Lordship.
CGC.
Yes.
CGC. The learned counsel appearing for the respondent number 7 submits that she may be granted some time to file Ukalatnama in this matter. After hearing learned counsel for both the parties, it is provided that learned counsel for the respondent number 2 on next date. We'll fix a date, suggested that in the second week of September.
September, Lordship.
9 September.
Lordship.
File one status report by way of an affidavit on 9th of September regarding the present status of the project, both physical and financial. List the matter on 9th of September.
Obligation, Lordship.
For others, item number 13.
Maybe, Your Lordships.
Yes.
Lordship, there is a delay of 83 days in filing the present writ appeal.
Okay.
The delay have been explained in my paragraph 19 to 13 of this IA.
No, today only we will issue notice.
Lordship, I have served copy to all the respondents.
Maybe. Mr. Angami, you are appearing here in this matter?
Yes, Your Lordship. I am appearing for respondent number 1 to 8 and 10.
1, 2,
8 and 10.
And Madam Yufa?
I'm appearing on behalf of my senior Joshua Ishiki for respondent number 9.
Respondent number 9. In this petition in this interlocutory application under Section 5 of the Limitation Act, the petitioner has prayed for condonation of delay of 83 days in preferring writ appeal against the judgment against the order dated 27 January 2026, passed in review petition number 4 of 2023. And also the order dated 28/4/2023, passed in writ petition within bracket civil number 61 of 2019. Where is the petition? The documents placed on record. Let notice be issued to the respondents, returnable in 2 weeks. Step upon respondent number 3, 4, 5, 6, and 7 be taken by speed post. Anybody appearing for Director General of Police? Oh.
Yes, Your Lordship. I am representing them.
Okay. You are 1, 2, 3, 4, 5, 6, 7,
8 and 10.
Okay. 8 and 10. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter on after 2 weeks. 9th of September. 9th of September. In the
Lordship, can it
meantime,
be on
instead of the respondent may file their
Can it be on
objection.
16, my lord?
16 will be too long. Huh? 16 will be too long.
Much obliged.
Obliged.
Item number 14.
Make this, your lordships. Your lordships, this IA is for condemnation of delay of 178 days. Arising out of Great Appeal 40 and 41 of 2026, your lordships.
Okay, heard, miss. Your name?
Innirinla.
Learned counsel for the applicant. And madam for
For respondent number 125.
respondent number 125. And for respondent number 6, anybody? Gauhati High Court.
Standing counsel is there, no?
This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 178 days in filing the connected writ appeal.
Please, my lord. Lordship, I'm appearing on behalf of Mr. A. Zimomi, standing counsel for Gauhati High Court, my lord.
Okay. Miss Esther, appearing for Esther.
Mr. A. Zimomi,
Azimami,
standing counsel for High Court.
standing counsel for the High Court.
R6, my lord. Lordship, I may be allowed some time to seek instructions, your lordship.
Issue notice to the respondent returnable on 9th of September. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. Ms. Esther, learned counsel, appearing on behalf of Mr. Zimomi, learned standing counsel for the respondent number 6, prays for granting her some time to obtain necessary instruction. Fair allot, list the matter on 9th of September.
Item number 15.
Your lordship, similar matter.
Similar matter, okay. Same order. And same date.
From the supplementary cause list for orders, item number 27.
May it please your lordships. Lordship, the instant IA is referred under section 430 of the DNS, praying for suspension of the
May I bless your lordship?
Yes.
This could be one of the longest Sumudu PIL since 2019. In fact, I'm appearing for the 77th time today.
Okay.
In this case.
Okay.
Anyway, Lordship, may kindly see the last order passed on 3/6/2026. In view of certain avoidable circumstances, on 2 occasions the matter could not be taken up. But Lordship may kindly see the order passed on 3/6/2026.
We have seen.
Yes. Now,
we have also gone through the affidavit.
Yes.
Filed by the respondent number 5 and 6 and 7.
Yes. And then
But,
the affidavit filed by respondent number 5 is chief engineer.
The progress is
Zero.
Zero.
The progress is. So this, I have a simple prayer today, Lordship.
Yes.
My Lord, Lordship may kindly see the last order passed. Paragraph 18.
Yes.
3/6.
Yes. Respondent number 21.
The contractor, Lordship. The contractor, in spite of notice, contractor is not appearing. Yet to appear before the Honorable Court.
Okay.
And he is the man responsible on the ground.
Okay.
So my respectful submission, Lordship, is that because Lordship, with regard to bitumen blacktopping in view of the rain, that is one aspect to be considered. But at least the road has to be maintained.
Yes, yes.
So that we are all
At
traveling.
least the potholes.
Yes, at least the potholes has to be filled up, and the road has to be maintained. In fact, Lordship, in the first week of August, it was widely publicized in the newspapers that in the Naga hospital area, the general public have filled up the potholes using their own materials. That is the situation. So my respectful submission is that if a direction may be given for personal appearance of the contractor on the next day, along with the executive engineer concerned, because on the other occasions the executive engineer has appeared and highlighted the reasons, so that Lordship, certain direction will be given.
Executive engineer of State PWD.
National Highway.
PWD National Highway.
Okay.
So, my Lord, just I think respondents. My Lord, last occasion the executive engineer also appeared. So, my Lord, if the direction is given for personal appearance of the contractor along with the executive engineer, with the direction that to the executive engineer to convey to the contractor concerned to appear on the next date, then that will serve the ends of justice, because on that day, Lordship, we can find out from the horse's mouth what is the reason for zero progress. Lordship may kindly see the financial progress of the work. If the Lordship may kindly see the last page 79. Page 82.
Yes.
Lordship, we kindly see the financial progress 35%, 60%, 85%, 100%. And now at page 80, the physical cumulative progress appears 53.89. And Lordship, we kindly see at page 81, appointed date is 25/11/2025 and scheduled date of completion is 25/10/2026.
But would it be possible to complete the same within this short period?
That aspect, this Honorable Court in due course has to consider, or for the respondent authorities, whether you will accept the contract. But at the meantime, at least, Lordship, maintenance should be there so that we don't suffer. At least So that is with regard to the Lordship respondent affidavit of respondent number 5, and Lordship the respondent number 6 and 7 also has filed the affidavit. So
Yes, but who is representing respondent number 6 and 7?
so let him highlight on the basis of the affidavit, then the appropriate order be announced.
If your lordship may kindly allow me to read affidavit file on.
No, not necessary. You first answer to some queries.
Yes, lordship. Yes.
Which we will put to you. Number 1,
Yes,
the package in respect of package 1,
lordship.
the maintenance work,
Yes.
whether contractor deployed or not.
Yes, lordship.
Deployed.
Yes, lordship.
When?
Lordship, we have stated in our affidavit.
No, your affidavit is not clear.
10th of July 2026. Paragraph number 2.
It says contractor will be deployed
Lordship.
at the site shortly.
Contractor
LOA
will be
was
deployed.
issued to MS22 Group on 10/7/2026. That is the statement made in.
No, you come to last sentence of that paragraph.
Yes,
the
Lord.
contractor will be deployed at the site shortly. Our question is whether contractor is deployed or not.
Yes, Lordship, the contractor is already deployed.
When?
Lordship, I have to get the date, the exact date when it was deployed, but
And,
LOA was issued on the 10th
Only
of July.
deployment will not do, but whether he has started any work or not.
Yes, Lordship.
Lordship, during my visit, because I'm compelled to go and see it. So
Yes.
during my visit, I could see some filling of the boot holes. In fact, I have inquired from the staff also. What
Yes.
has happened is because of the rain,
Yes.
some of the black boot hole filling is already gone.
Okay.
So the quality of the work is not satisfactory, which I have personally seen.
Okay.
Quality of repair and maintenance is not, and it will require maybe because of the monsoon. I don't squarely blame them also because after in view of the heavy rain, some defect may be there, but that requires proper repair. And package 2, Lordship, the
Yes.
defect liability is not yet expired, but they are in spite of the direction by this honorable court. They are not maintaining. They have not done anything.
Lordship, as far as 2 is concerned, package 2, we have issued several notices to the contractor because it's under DLP. So we are also preparing an estimate at the recent cost of the contractor. Because if you don't maintain, we'll be compelled to engage a new contractor to execute the work of maintenance.
But when?
That is the issue.
Lordship, it depends on the contractor. If he fails to execute, Lordship, then we will be compelled because we are already in the process.
If he fails to undertake any repairing work in this year,
Yes,
would he remain idle for the entire year?
No, Lordship, we have done our part. As per the contract agreement, Lordship, we have issued notices to the contractor. And that is part of the contract agreement. Now we are in the process of preparing an estimate to come up with an estimate and also to engage a new contractor if it's required, Lordship.
Lordship, direction was given as early as 3/6/2026 for maintenance of package 2. Till date, nothing has been done. So, let it be a time bound. Let it be completed in a time bound manner. The process which you are doing.
So suggest
Lordship,
that.
because at the most maybe it can be done in 2 weeks also. Because, my lord, if they are not coming forward, then what prevents? Because somebody is maintaining package 1, that can always be extended also for that matter. So that should not be a problem for them. If there is a will, definitely there will be a way for NHITCL to maintain. Because Lordship, I did not speak about the condition because Lordship knows better.
So far as the maintenance is concerned for package 1 and 2, we can file it by way of an affidavit about the latest status of both the packages, Lordship.
No, we are not concerned with your latest status. We are concerned with repairing work.
Yes, Lordship. With regard to that, Lordship, we can file an affidavit, Lordship, as to the extent of work that they have executed.
No, in respect of package 2, you complete the repairing work within 2 weeks. Within
Lordship,
2 weeks.
it is already been executed by the contractor because he has to maintain within a period of for a period of 5 years.
No, as per the submission of learned counsel for the petitioner, no work has been started till today. In package 2.
Lordship, yes, we also understand the fact that Lordship, the monsoon season, not much can
Maybe,
be done during
maybe.
this season, Lordship.
But at least the put
That,
holes can be filled
that
up.
cannot be
That
that
can be
cannot be
taken
the
care of.
excuse.
Yes, that can be taken care of by the contractor, Lordship.
Within 2 weeks, you complete the repairing work in package 2.
Put 1 and 2,
That-
Lordship.
that
We'll
I have
put
to
1
get the
and 2.
instruction, Lord.
Put 1 and 2.
Both 1 and 2. Okay, both 1 and 2. 1 and 2. 2 weeks.
Here, put holes in for package 2. Separate. Lordship, as per the instruction which I've just received, now the authority has already taken the decision to engage a new contractor. So we'll have to float.
For package 2.
For package 2, for maintenance. Lordship.
But when the process will over.
In the meantime, the existing contractor should take care
But
of it.
meantime, we extend another 1 week, 3 weeks.
Yes, Lordship.
3 weeks, you complete the repairing work, both package 1 and package 2.
Yes, my lord. Yes, my lord.
And what is the status in respect of package 3?
Lordship, contractor is being engaged. Respondent number 15.
May I please, my lord. Lordship, I'm appearing on behalf of Mr. N. Mozoy, Lordship, that is the contractor for package 3, and I'm being informed that 90% of the work has been done, Your Lordship.
In fact, Lordship, in paragraph 5 of the affidavit, it is clearly mentioned that it is expected to be completed by end of August 2026. So, Lordship, the next day, after 3 weeks, let him also file an compliance affidavit of completing the project.
You go for respondent number 15.
15, Lordship, for N. Mozoy, Lordship.
Lordship, may I see paragraph 5, because the timeline given is August 2026 to complete. So, after 3 weeks when the matter is listed, let the respondent file a completion affidavit.
Okay. Okay, we'll pass the order.
Oblige.
Okay. And the executive engineer of National Highway
My lord,
and the contractor shall
let it
remain
be done
personnel
through
present.
the letter additional AG who is appearing on behalf of the executive engineer.
Okay. So he has to remain present before the court on next date.
Along with the contractor.
Along with the
And the executive engineer may kindly be directed to inform the contractor also. Because every day they'll be in touch on the ground.
Okay. Then on 9th of September? 9th of September? We'll list the matter on 9th of September.
No problem.
Okay.
The earlier the better for us.
Yes. We'll pass the order.
May I please, Your Lordship, if registry will be directed to reflect the name of Mr. N. Mozoy as counsel for respondent number 15, my lord, in the cost list, Your Lordship.
To reflect his name?
Yes, Your Lordship.
Okay.
Much obliged, Lordship.
So, Lordship.
But madam, you see. So Mozoy's name has already been cleared by the collegium.
Yes, my lord.
So would it be proper to reflect his name at this stage?
Lordship, he has been appearing in this case.
Appearing?
He has been appearing. Only today in the cost list his name is deleted.
Okay. Then we'll...
Not as a new client.
Okay. We'll pass the order.
Item number 3.
Have you seen Lordships?
Yes.
Lordship,
I'm for a blend, and this appeal has been referred by the Union of India, my lord. And this subject matter burdens with a domicile, my lord. Here, my lord, I have a very limited grounds. So before coming to the records, allow me to highlight the facts, my lord. My lord, the advertisement, my lord. The commission, that is the SEC, they have advertised one online applications on dated 21/7/2018. And in this advertisement, my lord, specifically they had mentioned to enter the correct domicile, which my lordship will find it in page number 88, not 3, my lord. Page 88, not 3. Only the relevant portions, 88, not 3, my lord. My lordship had found it 88.
88,
Not 3, my lord.
not 3, yes,
I may be allowed to read.
yes.
As vacancies have been allotted to the concerned states or UTs, candidates are required to submit domicile or permanent residential certificate of the states UT indicated by them in the online application form at the time of DME documents verifications, failing which his or her candidature will be cancelled forthwith, and a candidate will not be allowed to appear in the detailed medical examinations. If a candidate produce domiciles or permanent residence certificate BRC issued by a state other than the state mentioned in his or her applications, he shall not be allowed to change the state at the time of document verification, and his or her candidature shall be cancelled straight away. Candidates are therefore continued to fill applications form very carefully, my lord. Here, the commission staff indicated regarding the domiciles very very clearly, my lord. And since since the candidate has to apply the form through online platforms, my lord, and also regarding the domiciles. And also, my lord, why I'm concerning to the domicile is that when we look the candidates of the domiciles is taken as a mandatory, my lord, because there are various posts. Yes, my lord, there are various posts, categories, and zones of selections covered under this recruitment. So in this aspect, we can also observe that, my lord. Looking at the
No, they have mentioned their domicile as state of Nagaland.
My lord.
They have stated their domicile as state of Nagaland.
Exactly, my lord. They have the candidate here, the respondents, they have mentioned the domiciles as a state of Nagaland. I don't have such dispute on this. However, my lord, we also have to see this.
No, Mr. Counsel, you see, the learned single judge,
my lord,
relying upon a decision of Honorable Supreme Court in the case of Vasist Narayan Kumar as a state of Bihar, has held that the discrepancy is trivial in nature and inadvertent and bona fide, and they never derived any benefit from the same.
Yes, my lord.
So what is wrong with that finding of the learned single
No,
judge?
my lord. So far here the advertisement is concerned, my lord. They have written an allotment. So in terms of the Gauhati, my lord, 3 states, there is the Tripura, Arunachal Pradesh, and Nagaland. They had allotted a certain process, my lord. So when it comes to the allotment of a certain process, my lord, it has been distributed into the state-wise as well as a district-wise. My lord, this is my concern. And so far here the petitioner is concerned, my lord. They have at the time of submitting their form through online portal, they have written as the Dimapur. And while in the BRC, that is the indigenous inhabitant BRC, that it has been reflected as the Gauhati. So it is incorrect.
Yes, Gauhati.
No, my lord, as Wokha.
Ukha.
Yes, my lord.
So what wrong with that? If he originally belongs to Ukha,
my lord,
and at the time of filling up the form, he was in Dimapur, then if he writes Dimapur as his place of staying, what wrong with that?
Correct, my lord. But my lord, we can also observe in other faith.
Anyway, he belongs to the state of Nagaland.
Correct, my lord.
Yes.
However, my lord, we can also observe in other faiths, such as like allotment. they have reserved an allotment. So when it comes to
No,
allotment,
you
there will be a various of
no,
vacancies,
you
my lord.
see, allotment is in respect of the state, entire state,
My lord.
not in district wise, right?
My lord, if I were to come on this, then my lord, since all those records data has been digitalized, so all those has been recorded, so they must have service or analysis, my lord.
Maybe subsequently those data can be corrected.
So in terms of this, since they have reflected as an allotment, so there might be some reservations or there might be some allotted vacancies to the state as well as the district wise, my lord. So these are my contentions, my lord.
These are trivial in nature. They have not derived any benefit. And you see, there is another decision of Supreme Court, three-judge bench decision, Avatar Singh versus Union of India.
My lord.
Avatar Singh versus Union of India, reported in 2016, 8 SCC, page number 471.
My lord.
Three-judge bench decision. There, some proposition has been laid down, have been laid down. You do one thing, you please go through that decision,
my lord.
three-judge bench decision.
So I think Supreme Court has
Actually, Your Lordship, if I may, similar matter, Your Lordship, the respondent has preferred an appeal. SLP, both SLP, civil appeal were registered, and this Honorable Appeals Court has dismissed similar arising out of the same advertisement, Your Lordship. Yes,
Okay.
there's a discrepancy, mismatch in the permanent resident and the address domicile address. I have those orders, Your Lordship. Well,
Yes, my lord. In connection to this, I have also one order, my lord. However, the ground speaks differently, my lord.
No,
The contention, sorry, allow me. Yes,
arising out of the same advertisement.
exactly, my lord. However, in their grounds, my lord, the petitioners, they had submitted that inadvertently they had submitted a wrong document in respect to the domiciles. However, she was being assisted by one of the cafe owners. So those are the grounds. However, in my case, so far here the petitioner is concerned, they have not mentioned instead they are challenging, instead they have challenged domiciles, my lord.
So, yes, Mr. Zami, can you produce that decision?
yes. Your Lordship, before that, the matter is listed for admission.
This one?
This one.
No,
And
no,
then-
if there is no merit, we will not admit the matter.
Yes, and then that is what I would like to impress upon Your Lordship. This Honorable Court in Sonarambora versus Assam State Apprenticeship Board, Your Lordship, has held that admission of appeal is not a matter of right. I'll take Your Lordship to page para 20. Para 20, Your Lordship.
Yes.
We have considered the submission of the learned counsel for the parties and have also gone through the impugned judgment order passed by the learned single judge and also given our anxious thought to the points raised at the time of admission hearing of the appeal. Admission of writ appeal is not a matter of right, like civil first appeal or criminal appeal, but when a prima facie case is made out for examining the judgment order of the learned single judge, then only the court should admit the appeal for hearing. Even if the opinion of the learned single judge is erroneous, then also the appellate court cannot interfere with the order of the learned single judge unless it is totally perverse and violative of provision of law. At the time of admission of appeal, the appellate court should be more cautious to examine prima facie merit of the appeal, and when there is no prima facie merit in the appeal, the court should avoid admitting the same. So this is what has been held by the Supreme Court in Sonambora's case, Your Lordship. Now, may I take Your Lordship to the judgment? Page 286.
Yes.
Lordship has got it. I'll just read out para 5, 6, para 3, the facts. This is for the facts, and then I'll take Your Lordship to the finding and observation. The 6 petitioners are all indigenous residents of the state of Nagaland in various districts. Pursuant to a recruitment process for, amongst other, the post of constable in the CRPF, the petitioners had offered their candidature. As per the advertisement, the selection process was based on 4 stages, namely computer-based examination, physical test examination, physical standard test, and medical examination. On being successful in all the aspects, the petitioner were offered appointment on 15/2/2021, whereafter they were reported and were assigned duties. The petitioner was also given false numbers. However, by the impugned communication dated such and such issued by the office of the DIG, the offer of appointment was cancelled on the ground that there were discrepancies in the district of domicile and the district of permanent residence. Though the letter indicated that further verification was being done, the offer appointment was already cancelled by the order dated such and such, and since the representation filed by petitioners were rejected, the writ petition was instituted. Subsequently, the order dated 31/2022/23 was passed of final cancellation, and accordingly, as indicated above, the amended writ petition has been filed. Para 14, page 294.
Yes.
The facts noted above will boil down, these are the observation and findings, Your Worship. The facts noted above will boil down to the issue of a disclosure made in the application for recruitment submitted by the petitioners. The rejection of the appointment by the 2 orders that is such and such are on the ground that there are discrepancies in the addresses pertaining to the domicile and permanent residence. The aforesaid discrepancy is not disputed. 15. What is therefore required to be examined is whether the impugned orders are sustainable in the. Your Lordship, may kindly pause here for a moment. Your Lordship is like this. All the petitioners, they are from remote village, Your Lordship, but in search of employment, job opportunities, they come and stay in different district headquarters, stay in with relatives. So that is how the discrepancies was, Your Lordship. Otherwise, as Your Lordship has rightly said, they all are from the state of Nagaland, Your Lordship. 15, Your Lordship. What is therefore required to be examined is whether the impugned orders are sustainable in the aforesaid ground. Taking a very technical approach, the impugned orders may not be found fault with, as they are also an undertaking in the application made by the candidature regarding their candidatures, appointments liable to be cancelled in case of incorrect, false information. However, what is, and Your Lordship, my respect will say, it's not a false information, Your Lordship. They were staying, just that they were staying permanent residence, the remote village, and that they were staying. The information is not false, Your Lordship. However, what is required to be seen is whether there has been any malicious intention on the part of the petitioner to gain undue advantage by making a disclosure which is not in conformity with the certificates given. There is also, and Your Lordship is like this in the state. Supposing I belong to Mokchong district, Your Lordship, and though I am staying here, my permanent residence can be given only by Mokchong district. From the district to which I belong, I cannot obtain certificate from here. So that is the case, Your Lordship. Now, however, what is required to be seen is whether there has been any malicious intention on the part of the petitioners to gain undue advantage by making a disclosure which is not in conformity with the certificates given. There is no dispute in the bar that all the petitions are permanent residents and indigenous people of the state of Nagaland. This court has also noticed that in the advertisement, so far as the state of Nagaland is concerned, all the districts are stated to be militancy affected districts where additional vacancies were to be filled up. This court also has been apprised, as recorded above, that the petitioner number 4 and 5, who belong to Peg district, which is one of the border guarding district, had not been disclosed that aspect which could have been given them additional benefits. Here, Your Lordship, respond number 4 and 5. They belong to Peg district, where the additional vacancies are there, Your Lordship. But they have not given that address where they have given, say for example, they have given Kohima. So they have lost benefit. They could have taken advantage of it, Your Lordship. So in fact, instead of getting undue advantage, it was at their loss. But fortunately, they were selected. That is different, Your Lordship. Under this condition, it would be difficult to come to the conclusion that the discrepancy mentioned above would have a material bearing in the decision to reject the eligibility of the petitioners for appointment. Though the stand of the respondent is that a false statement is made, there is a thin line of distinction between a false statement and an incorrect statement. And to examine that aspect, one has to see as to whether the incumbent has derived any advantage from such statement. In the instant case, this court has noticed that no advantage of any nature has been derived by such incorrect disclosure of the facts, more so when it is not in dispute that all the petitioners are indigenous residents of the state of Nagaland. 16. So far as the first impugned order that is concerned, this court is also of the view that when the entire matter was said to be under verification, the cancellation could not have been made, and at best such appointment could have been given a bench, which was not done. In any case, this court is of the view that the action of cancellation which has been communicated by order dated such and such is on absolute tribal ground, which would not have any material bearing on the aspect of eligibility of petitioner to be appointed as constable GD in the CRPF. Now, para 17, your lordship has referred to it already. Now, so based on this, your lordship, 18, considering all the aforesaid aspect and discussion made above, this court is the view that the impugned order dated such and such by which the appointments of petitioner have been cancelled are sustainable in law and accordingly set aside. The petitioners are accordingly to be inducted back in service as constable for wait. Now, your lordship, what has happened? This is the judgment has been passed on 21st May 2024. Your lordship is more than 2 years now. Now, because of non-compliance of the direction passed by this honorable court, a contempt petition has been filed. Now, in the contempt petition, your lordship, so in one paragraph, the mention has been made regarding filing of SLP in similar matter before the honorable apex court. So that affidavit, your lordship, because next is the case diary of the Honorable Supreme Court and the record of proceeding. Both are relevant because they are altogether 6-7 cases, your lordship, all these books. Now, in contempt, the affidavit, your lordship, may I take your lordship to page 4. Page 4, para 2.
Yes.
That as various SLP numbers such and such, title 6 line were pending on similar matter of domicile mismatch before the Honorable Supreme Court of India. So I'll be taking your lordship to the case study where all these cases are mentioned, your lordship. Decide to file appeal against the judgment order dated such and such passed in honorable by this honorable court. Now, may I take your lordship to the case diary, to the case where this is the diary of the Apex Supreme Court Registry, your lordship.
Yes, yes.
Now, the first case, this is Union of India versus Neetu Lakshmi. Your lordship may kindly come to para 2. Your lordship has to do some comparison, your lordship. So the first case is Union of India versus Neetu Lakshmi. Your lordship has got it?
Yes, got it.
And this here, case number is given, civil appeal 000606. And next line, second line, SLP is given 13883. Here, your lordship, civil appeal number is not there, but the same petitioner.
Yes.
And then next page, your lord, and then this is status of the case, dismissed, order dated 3/9/2025. Disposal type, dismissed. Your lordship has got it?
Got it.
Yeah. Then next page, your lordship. This is the second case, Union of India versus Brajesh. Lordship has got it. Even here also, only SLP number is given 14116, but this is subsequently registered as Civil Appeal 420. Lordship. Here, same status, dismissed, disposal type, dismissed. Lordship. This dismissal order 3/9/22, same date. Now, third page here, Lordship. Union of India versus Rajesh. Now, here, your lordship, here the case number, here also in contempt para 2, only SLP number is given. Now, this is civil appeal number 000144, your lordship. Now, same. Now, may I take your lordship to the record of proceeding where all the cases are mentioned. This is tagged with civil appeal number 144 of 20. This is Union of India versus Rajesh, tagged with other analogous matter, Your Lordship, link cases. Now with civil appeal 606, that is Nithu Lakshmi. Then civil appeal 420 is Brajesh, Your Lordship. Now next SLP number. Your Lordship may kindly come to para 2 of the affidavit file in contempt. Fifth line. SLP number 30303, Your Lordship.
Got it.
Gone. So here the party is Union of India versus Sunkara Dharma. Next, Your Lordship, is SLP number 1195. This is Union of India versus Dharamdev. Now the last case is SLP number 12511, Union of India versus Shamsundar Verma. Now this is dated 3/9/2025. Next page, Your Lordship. A common order in civil appeal number and common order in SLP number 3. We are not inclined to interfere with the impugned judgment and order of the High Court, hence the special leave petition are dismissed pending application. So now, Your Lordship, the problem is this. As per the record, Your Lordship, the Honorable Apex Court has dismissed similar matter on 3/9/2025. Lordship. Now, only after dismissal of the civil appeal and the SLPs, Your Lordship, the present appeal is filed on 19/9/2025. 19/9/2025. Disposed on 3/9/2025. Appeal filed on 19/9/2025. But in the appeal, Your Lordship, present appeal, by suppressing the facts regarding dismissal of the civil appeal, Your Lordship, instead the appellant has taken the pendency of the civil appeal and SLP as one of the question of law involving this present appeal, Your Lordship. May I take Your Lordship to appeal memo, page 11. Appeal memo, page 11, Your Lordship.
Yes.
Your Lordship, yeah. Then question of law. Now, next page 12. F, last paragraph, Your Lordship. Lordship has got it?
Yes.
Whether the learner's English was justified by not appreciating the fact that subject matter of change domicile, mismatch, and request for change in CAPF examination, the same is pending before the Honorable Appeals Court, where an order similar to the order impugned herein passed by the learner's English. And Your Lordship, the affidavit in opposition in the contempt was filed after filing of this appeal, and that is why that ground was taken. Let the matter be listed, the contempt be listed after disposal of this appeal, Your Lordship. Now, the conduct of the appellant, Your Lordship. In my respectful submission, the appellant is not before this court with clean hand, Your Lordship. No. And even on that ground alone, Your Lordship, on suppression of facts, Your Lordship, this appeal is liable to be dismissed, Your Lordship, as held by the Honorable Appeals Court in the case of K.D. Sharma, which I have given reported in 2008-12 SCC 481, Your Lordship. Para 34, 36, 38, and 39.
Yes.
Lordship has got it. Para 34.
Got it.
Yes. So, in suppression of facts, we are going to the matter, it should be dismissed, Your Lordship. That is, we are now, Your Lordship, the ratio laid down in KD Sharma squarely covers this case, Your Lordship. Now, coming to the merit also, Your Lordship. Even on merit, Your Lordship, There is no illegality or perversity in the judgment passed by under a single judge. It cannot be said that the judgment order, in fact, the judgment and order is in conformity with the principle of law laid down by the Honorable Appeals Court, Your Lordship. Because of that mismatch, Lordship, no undue advantage has been gained by the petitioner or the respondent here, Your Lordship. Moreover, Your Lordship, when in connection with similar matter, Your Lordship, the Honorable Appeals Court has dismissed the civil appeal and then the SLP, Your Lordship. In my respectful submission, nothing remains in this present appeal to be examined and determined by this Honorable Court, Your Lordship. So in my respectful submission, the appeal is devoid of merit. This liable to be dismissed without it. Much obliged, Your Lordship.
Yes, any reply? No reply.
Yes, my lord.
So
Yes,
we are dismissing the appeal.
Obliged, Lordship.
Like,
But we will be uploading the order on Monday.
Lordship.
my lord.
Obliged, Lordship.
Item number 4.
Please, Your Lordship. Lordship, here we have filed appeal against the single petition. Lordship, in this connection, we have filed an IA for confirmation of delay. However, we have filed the confirmation of delay on 25th November 2025. And thereafter, we have filed an additional affidavit. Lordship, this Honorable Court has directed us to file an affidavit with regard to the typical error, Lordship. And accordingly, we have filed affidavit on 25th of August, Lordship. However, Lordship, here also we have a error, Lordship. So I'm allowed to withdraw and then to file affidavit.
Again,
Lordship, there is a slight error with regard to here the respondent is the engineer works and engineer road and bridge Noklak, Lordship. So
that's all right. But you see, this application was filed when? In the year 2025.
Lordship.
So for filing affidavit, you have been taking a year time.
Lordship, in fact, they have the respondent, they have filed an affidavit in opposition with regard to the continuation of 277 days, Lordship. And I have made an attempt to explain regarding the continuation of delay, Lordship. However, Lordship, since there was insufficient grounds, this Honorable Court has graciously granted me to file an affidavit, Lordship.
Okay. Heard, Mister, your name?
Vijmomi.
Vijmomi, learned. Is he?
Government advocate.
Learned government advocate. For the applicant and madam?
Vikonaki-san.
For the respondent.
Yes, Lordship.
For the respondent opposite party. The learned counsel for the applicant submits that pursuant to the direction of this court, an additional affidavit was filed on 24th of June 2026, but in the said affidavit, some inadvertent mistake has been crept in, and as such, he submits that he may be allowed to withdraw this additional affidavit, and to file a fresh one, making necessary correction. Any objection?
Lordship, since we filed our affidavit in opposition, kindly grant the applicant to correct only this typical error.
Lordship.
Yeah,
Only to that extent, Lordship.
Yes, Lordship,
We have
only to
filed.
this extent of correction.
Okay.
Yeah, no other correction.
No, he want to withdraw this application,
Lordship.
withdraw this affidavit.
Yes, Lordship,
And he will
but
file a
kindly
fresh one.
reflected this typical error may be corrected only. Since I've already filed my affidavit in opposition.
In fact, I have explained only to that extent, not on other issues.
Okay. Pair allot receptionalize the matter on
After a week.
After a week. However, it is being clarified that The applicant may correct the date.
Lordship, respondent number 7, who is the respondent number 7 in WPC 145 of 2024?
No, to correct the name of your respondent.
Respondent, it should have been works and housing. It should have been road and bridge. Instead of that, I have.
Correct the department. Correct the department. Okay, all right. All right.
I look.
Item number 5.
May I plead Lordships?
Yes.
Lordships, I am appearing on behalf of the petitioner.
Yes.
Here, your Lordships, before I go into my grounds for challenging the detention order, on the last date when this matter was placed before the Honorable Court, I apprised the Honorable Court that my detention period was already over. So, in the meantime, in the state's affidavit, they have not stated that my detention order was extended. So, accordingly, Learned State Council sought time from the Honorable Court for seeking instruction. So, in the meantime, your Lordships, they have provided me a further extension order, but that extension order is 19th of August, whereas my previous extension order had already expired on 15th of August. So, in that view of the matter, my detention order is illegal, your Lordships. Because again, my extension order was extended after the expiration of 3 days. Your Lordship, of my petition may kindly.
Your detention order was extended from 15/8/2026.
Lordship.
And they have passed the order on 19.
Lordships.
19/8.
Lordship. So my first initial 3 months period, that is 90 days, had already expired on 15th of August. On the last date also, I had apprised this Honorable Court, but the State Council has sought time for instruction whether there was any extension or not.
Okay, Mr. Surin, we will examine the file, whether the file is available.
Yes.
So when the order was passed?
Order was passed on 18th May 2026.
Mr. Surin, I am asking the Learned State Council.
Your Lordship, on 19th of August.
19th of August.
Yes,
After a lapse of 3 days.
Your Lordship, here, though the detention order was issued on 18th of May, the detention order was served on, in respect of Pawan Kumar, it was served on 20. I have the records 20 of August. So the date on which he received the detention order is counted, Your Lordship. So there is no gap, Your Lordship.
No gap.
No, Lordship. There is no gap, Your Lordship.
Lordship, I may draw the attention of the Honorable Court, page 44, Your Lordship, my first detention order. Annexure 8, page 44, Lordships.
Yes.
Lordship, at the last para, for an initial period of 3 months. So, from the date of 18th May 2026, 3 months period is expiring on 15th of August. After that, there was no extension order.
Your Lordship, here, if we look at the records, Your Lordship, in respect of Pawan Kumar, the detention order was served to him on 20th of May 2026. So the 20th of May 2026, and in respect of Shahid Ali, it was served on 21st of May. So the detention or the 3 months period will count from this date, Your Lordship. 20th, in respect of Pawan Kumar, 28th of May, and in respect of Shahid Ali, 21st of May.
then your lordship, in that view of the matter, the state is themselves admitting the fact that I was provided my detention order after a lapse of 2 days. Why? They have to explain. When my detention order was passed on 18 May, and they have served that copy to me on 20th of May, they are admitting this fact.
But your lordship, it was well within the prescribed period, your lordship, well within the prescribed period.
So where it is provided that this period of 90 days has to be counted from the date on which the detention order was served to the detainee.
Your lordship, because he was already in custody, so
Maybe.
detention will count from the period when he's put under detention.
So he's already under detention.
Yes, your lordship.
Then?
No, he was already in custody.
Yes.
So he was served the detention order on, one was served on 28th of May, one was served on 21st of May. So that period will count the date of detention, your lordship.
Where it is provided in the act.
Lordship, as such, there's, as far as I
Because detention order is 18.5.
yes, 18.5.
So why should we count from 25?
Because on before he was served the detention order, he was in judicial custody. But the detention period will count from the day he received the detention order.
No, that's all right. But where it is provided?
Yes, sir. Your Lordship, as far as the act is concerned, there's nothing as such provided in the act.
Then?
But there's already Your Lordship, in a similar case,
Initiative.
the one of the petitioner that has taken this ground, and this honorable court has taken has not accepted that ground. I can place that order.
No, that is a different aspect. This court has not accepted, but there must be some legal framework, no? If it is not provided in the act or in any of the decision of the Supreme Court, then can we accept the same? Mr. Surena, whether this subsequent extension order is part of the record?
Your Lordship, it's not part of my petition since only on 19th I had received this. But in any view of the matter, if my first initial order is illegal, then all the subsequent orders are also illegal, Your Lordship. They are also liable to be court.
You were not arguing on the initial order?
That order is not part of my petition, Lordship. Only on 19th I have received that, my extension order.
No, that's all right. But you have not argued on the initial order that it is illegal.
Initial order, Your Lordship, I would like to draw the attention of page number 11 of my petition, Your Lordship. Page number 11. Page number 11, paragraph 11, Lordship.
Not necessarily. If first order is illegal, then it will automatically go. Page number?
Page number 11, paragraph 11, Lordship.
Yes.
Yes, in this paragraph, I have quoted one judgment of this honorable court. Here in this particular judgment, the court has held that in my detention order, the detaining authority has to reflect that I was already under judicial custody in connection with so-and-so case, and there is every possibility of me releasing on bail. But that has also not been reflected in my detention order.
Okay, this is one of the ground.
Lordship.
Any other ground?
Any other ground, Your Lordship, regarding this page 16, where I have mentioned my grounds. Page 16, clause C, Your Lordship, one of the ground. Clause 6, here it says that under section 9B, when that detention order is passed, the detaining authority has to refer the matter before the advisory board within a period of 5 weeks. So that document also I have not received, but my learned state counsel is saying that the case record has already been placed before the honorable court. Regarding this issue also, whether within 5 weeks, my detention order has been placed before the advisory board or not, that is also I am contesting, Lordship.
Yes.
And
Any other
regarding yes, regarding this clause B of this ground, same page 16, after receiving this union's affidavit, they have stated that within such period, the state authority has already informed to the central government. So this one is I'm not pressing upon on that.
Okay, in respect of ground number E, you are not pursuing it.
Language.
Yes, Lordship, ground number, since when I personally met the detainee, he said that he does not understand any other language other than the Adivasi. But when he is receiving the detention order, his signature is there, he has written his name in English. So on that point also, I'm not pressing, because recently also when my detention order was given, I had signed in English as Pawan.
Okay. So you are not pursuing this ground.
Lordship.
Any other ground?
Lordship, that's it.
Okay. So, madam, can you demonstrate that the date of detention has to be counted from the date of communication of the order?
Your Lordship, since this issue was raised only now, I've not been able to counter it in the form of an affidavit also. Can I be given an opportunity for 1 week time? It may come up next week. I may be allowed to respond to that, because this issue had come up only today, Your Lordship.
Which issue?
The issue that after the expiry of the detention order, we have issued the confirmation order.
Which date has to be taken?
Yes,
Whether
Your
the
Lordship.
date of order or the date of the execution?
Yes, Your Lordship. Because in my affidavit, I have not countered this, because this issue is new, Your Lordship. He has raised only today, Your Lordship.
No.
Lordship.
He has pointed it out that since the first order was passed on 18th of May,
Yes, Your Lordship.
2026,
Yes, Your Lordship.
the three months period will expire on
15th, Lordship, 15th of August.
Yes.
Yeah.
Your Lordship, but in all the other cases also, but usually on the day that the detainee receives the detention order, that is counted for issuing the next order, Your Lordship, especially when the detainee is in judicial custody, Your Lordship. And Your Lordship, if he's saying that it has to be counted from the date of detention, he may also be allowed to prove before this court that it has to be this way, Your Lordship.
No, if it is not provided in the act itself or in any of the decision of the Supreme Court, then what to do?
Similar issue arose in one of the cases before this Honorable High Court, and the Honorable High Court has issued decided in favor of the state, Your Lordship, saying that it should be counted from the date of the detainee receives the
So
detention.
what reason is provided there? Where is that decision?
My apologies, Your Lordship, I have only one copy.
Okay,
here.
all right, no problem.
Lordship, may
Where is the
paragraph 30, page number 32, Your Lordship.
page number
Paragraph
32?
49.
Page number 32, paragraph number?
Page 32, paragraph 49. I may be allowed to read them.
Yes.
The Lordship, paragraph 49, page 32, paragraph 49. The order of detention in the present case was passed on 9/5/2025. Though on that day, that is on 9/5/2025, the detainee was in judicial custody, the detention order, the grounds of detention, and the supporting materials were served upon the detainee on 13/5/2025. Why it took the detainee authority 4 days to serve when the detainee was already in judicial custody is a fact well known to the detaining authority, has not been explained. No exception can, however, be taken in view of Article 22(5) of the Constitution and Section 3(3) of the DPS Act, as the date of detention of the detainee is 13/5/2025, and the confirmation order was shown to have passed on 12/8/2025. The contention advanced on behalf of the detainee that the confirmation was not passed within a period of 3 months from the date of detention of the detainee is found to be lacking force.
No, here the confirmation order was passed on 12/8/2025. The detention order was updated 13/5/2025. So
Here
how
also-
this
here also-
decision will help you?
Here also, the petitioner contended that there was a gap in issuing the confirmation order. Your Lordship.
No, whether this court has dealt with that issue.
Yes, Your Lordship, because they stressed on that ground as well, Your Lordship. Your ladyship was also a part of it. 49. Page 32.
No, that has not been deliberated here.
They had taken this as one of the ground in their petition, Your Lordship, so the Lord.
Even then the detainee was released here.
But it was on other grounds, not on that ground, Your Lordship. That prayer was not acceded to, Your Lordship. The other grounds.
His contention was expired. 9/5 after was 13/5 was
If I may, Lordship, I have.
Is it provided in the?
It's not. Execution, meaning the execution, meaning
Okay, we'll list the matter on Monday then.
Lordships,
File an
in
affidavit
any.
Wednesday.
Pardon?
Wednesday, can it be in Wednesday? I'll have to file an affidavit. If I'm allowed to file an affidavit.
No, if your file is available, why affidavit is necessary?
You can just
No,
get some
on this ground,
authorities.
on this ground.
Yes, Mr. Soren?
Lordships, even though I'm not admitting, even though I was communicated on 20, but still if we count the 90 days, it is expiring on 18th only, 18th of August. And whereas this order was passed on 19th of August. And secondly, my learned counsel is trying to divert the attention of this honorable court because in that particular case, that was the issue regarding passing of confirmation order. Here, I'm not challenging my confirmation order. I'm saying that no doubt my detention order was confirmed already. But after the period of 90 days, it has to be extended before expiring of 90 days. So that issue is different.
That is the settled proposition of law that before expiry of the period of 3 months, the fresh order has to be passed.
Your Lordship, in that case also I appeared. So in that case also, the confirmation order was passed during the pendency of the petition also, similar to this case, Your Lordship. So in that case, they had contested this issue also, saying that the confirmation was order was issued.
Okay, let it be on Monday then. You come with your instruction.
Yes.
Heard Mr. Surin, learned counsel for the petitioner, Ms. Ina Hole for the respondent, state respondent, and Mr. for the Union of India. Union of India. Heard in part, leaves the matter on Monday then. Monday or Wednesday?
Wednesday.
Since it's a habeas corpus, if it could be listed on Monday.
It can be, but okay, Monday then. Okay.
Lordship. Lordship, regarding next item, similar order may be passed. Is analogous case.
Okay. Similar order.
Analogous case.
Item number
6.
6 also.
Lordship.
For authors, item number 27.
Next is the Lordship.
Yes.
Your Lordship, I think there is nothing in the record to substantiate, but however, I think they're bringing one document, the bank statement.
Lordship, I have just received one document, if I may be allowed to please.
Yes, yes.
It's a front page of bank statement
statement.
wherein it state his the applicant's sorry, the
Wife.
applicant's father name has been mentioned there.
Okay,
Right. And the same is mentioned in my affidavit at page 7.
okay. So will grant you bail for a period of 1 week
Lordship,
from today?
Lordship.
Specific didn't we mention on the day of surrendering? Your
From
Lordship?
today's till today is
27th.
27th. Then 7th of September.
Lordship.
7th of September. Okay, we'll pass the order.
Oh, Your Lordship.
Lordship.
Much obliged, Your Lordship.
For hearing, item number 18.
Lordship, may I please, Lordship? Arguing counsel will be going through with his Lordship.
Okay.
Respondent, who's for the respondent?
Lordship, the counsel is unable to connect. He's finding it difficulty to connect. So,
You see, this matter is of 2022.
Lordship.
Today we are in 26. Almost last part.
Yes.
I'm for the respondent.
Respondents.
Yeah, the appellant have taken adjournment on so many occasions, and this appeal was on 2023, challenging the bill.
If you were not interested to pursue this matter, we'll dismiss it.
Yes.
Why should we keep the matter pending for quite a long time?
Even in the tricolor, majority are 69 witnesses, and only now 11 witnesses is going on to examination of PW 1112. So they're also on the absence of PWs and the prosecutor, on the frequent changing of the prosecutor, even the trial is delayed. And the
Frequent change of prosecutors.
Yes, my lord.
Trial is delayed.
Yes, my lord. In the absence of the PWs, the witnesses.
Lordship, my humble request, Lordship, at this stage, next item may be called so that arrangement for connection may be arranged.
Okay.
This matter. Last matter.
Last matter.
Last matter.
You see, we have some single bench matter also. So we cannot wait for connection.
Lordship.
On Monday, we have, is that somewhere else? Let it be on Monday.
Lordship.
If you fails to appear on that day, we will dismiss this petition.
Lordship.
Heard me, sir?
Noklem konyak.
Learned counsel for the appellant. The learned counsel appearing on behalf of Mr.
Sandy Anger.
Sandy Anger.
Special PP for NI.
Learned special PP for NI. Appearing on behalf of Mr. Sandy Anger. Learned special PP for the appellant and Mr.
Okay, no, so, my lord.
For the respondent number,
Only one respondent.
for the respondent. Learned counsel appearing on behalf of Mr. Santianger submits that Santianger would appear through VC, but he could not connect.
Lordship, the counsel for the NIA, there is Chaudhary, who is Ajit Kumar Chaudhary.
Yes.
So he was to appear today through BC, not Santiago.
Okay. Mr.
Ranjit Chaudhary.
Ranjit Chaudhary. RKD Chaudhary. Ranjit Kumar Dev Chaudhary.
Yes.
The Deputy Solicitor General of India. Okay.
Good afternoon, sir.
Yes.
Sir, here, sir, Ajay Kumar Sinha, sir, CIO of the case, sir.
Pardon?
Ajay Kumar Sinha, sir, CIO of the case, sir.
Okay, but
IO, sir, investigating officer, sir.
okay.
Sir, I am trying to connect the LG, sir, ASG, sir.
Yes, Mr. Chaudhary. Mr. Dev Chaudhary, kindly unmute. Mr. Chaudhary, you are not audible. The system officer.
Not audible plus.
Computer section. Anybody from computer? Come here. Just unmute. Unmute.
Am I audible, Lordship?
Yes, Chaudhary, now you are audible. Yes, Chaudhary, you are audible now. Unmute our this video and audio.
No, ours is. It's on.
Ours is.
Lordship, I am audible.
You are audible.
Lordship, I am very sorry, Lordship. There was some problem with the connection.
Yes. Yes.
May I please, Your Lordship?
Yes, yes.
Yes, Lordship, may I please, Your Lordship? Lordship, this appeal is directed against an order passed by the special judge on 20/06/2022, granting bail to the petitioners. Now, Lordship, this is a matter under the UAP Act. This is a matter under the UAP Act, and the petitioner is
Mr. Chaudhary, the quality of audio is very bad.
16, 18, and 22 of the UAP Act. Lordship, for a moment, if I can take your Lordship to the UAP Act, Lordship.
Yes.
I'm reading section 16.
Yes.
Section 16 is punishment for terrorist act. It says
whoever comes, Lordship,
Yes. Read it.
No, then he's disappeared.
Then let us adjourn the matter.
Monday.
Let it be on Monday. So Mr. Arcadius Odure, learned Deputy Solicitor General of India, appears on behalf of the appellant, yet the quality of audio is found to be very poor, and therefore it is provided that recusal lays the matter on Monday. Over.
We have this, Your Lordship. Lordship, I am appearing on behalf of Yamarwati, current citizen.
In item number?
Item 1, Lordship.
Your Lordship, I'm appearing for the petitioner. Your Lordship, we are seeking some time to file the rejoinder. If Your
Okay.
Lordship may grant us some more time, because there's a lot of petitioners, and at the same time, we have not received the affidavit in opposition of the center, Your Lordship.
Lordship, we have.
Then how can you file your reply?
We have received the affidavit in opposition of the state of Nagaland, Your Lordship. That's what we are working on right now. So we have not yet received the affidavit in opposition of the Union of India.
Okay. You are Mr.
That was supposed to be
Surjadas?
filed, Lordship.
You are Mr. Surjadas?
Yes, Your Lordship.
Heard Mr.
Yes, Your Lordship.
Surjadas, learned counsel for the petitioner. Mr. Learned counsel appearing on behalf of Mr. Gauhati, learned counsel for the respondent number, learned CGC, and Mr. Sanktam for
LD Sangam for state
respondent number 124. The learned counsel for the petitioner submits that he has received a copy of affidavit in opposition filed by the state respondent, and he may be granted some time to file his reply to the aforementioned affidavit. And further, he submits that he has not received a copy of the affidavit in opposition filed by the Union of India. Whether
Your Lordship, we do not yet know if it has been filed by the Union.
Whether it is filed or not.
Lordship, we have received the instruction and will be filing.
Okay.
Soon.
Okay. However, learned counsel appearing on behalf of Mr. Gauhati submits that the learned CGC has received the instruction and will be filing the affidavit shortly. Pair allowed registration list the matter on when?
2 weeks.
Your Lordship may, if Your Lordship may allow 3 weeks for me, please.
3 weeks.
I will be coming to Kohima, Your Lordship, from Calcutta.
Okay. After 3 weeks. Okay.
Yes. Any date, Your Lordship, I would be very grateful if any
After
date is
3
available.
weeks. Okay. On 15th of September?
15th of September. Just a second, Your Lordship. I'm fine, Your Lordship. With 15, 16 is fine for me, Your Lordship.
Okay.
Any day.
15.
I'm grateful.
This Your Lordship. Lordship, kindly allow me to take on this matter. There's an extreme urgency in this matter. The matter pertains to 22 primary school teachers, government teachers. And there is a protection by the Supreme Court also in regard to this. It is in regard to NI ways for taking breach course. Lordship, the last day is on Sunday, and the last working day of the office is tomorrow, Your Honor. If they are not given an interim, which has also been permitted by the court, then their service will become invalid. They've been appointed, they've been in service since 2017.
When do you want?
Right after the matter, my matter may be read. An interim, immediate interim order is required for the protection of the service.
Okay.
What?
Yes. Next item.
For admission, item number 2.
This is a case difference, fix for interim order. I don't have any other issue before the honorable court at present. My only issue is that 4 person are, if to go by this approval, 4 person are holding dual posts. And 4 GBs under the section, the other day I have read out, section 4. I'm only on this. A village council shall consist of members, section 4 of the village council. This is prima facie. A village council, my lordship has got it. only on this, my case is confined to only on this lordship, this statutory act. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages. The same being approved by the state government, provided that hereditary village chiefs, GBs, and AMs shall be ex officio members of such council and shall have voting right. So in this case, I have no other issue before the Honorable Court. Only this where I have the other day appraised my lordship that hereditary village chiefs means in Nagaland it pertains to Simi tribe, my tribe, and GBs also pertains to both hereditary village chief and GBs. They are of the they are same lordship. The respondent government is using now GBs. Otherwise, hereditary village chiefs, GBs. This will pertain to me and ANGS. ANGS is related to Konyak tribe. So here in Nagaland, there are only two tribes where hereditary village chiefs and ANGS, they are hereditary traditional ANGS, kings, that can be interpreted as king's law, village chief's lordship. So why I'm seeking interim order is that lordship, this 4 village chiefs, one is Chocho, and 3 others has been, who are ex officio has been inducted as village council members, and there is no law, there is no provision to induct them as village council members. And I have on the other day also I have submitted before my lordship that this is in order to deny the representation of, there are 8 clans at Lishami village, and in order to deny the clans, some of the clans, the village council member representative, 4 GBs, 4 chiefs have been inducted by themselves as village council members. And in the state of Nagaland, this may be the first instance where GBs, village chiefs, or ANGS can never be, under Section 4, can never be village council members. And if to go by this, now they will be holding dual posts. And prima facie on the basing upon the statutory act, lordship, they cannot. So here are 4 persons. I'm only on that route. I don't have any other grievances. So these 4 cannot be village council members. So I seek the indulgence of this honorable court that this comes within the purview of Article 371A, lordship. That is special status given to the state of Nagaland, and it comes under the customary law and practices. Only this. So my lord, basing upon this, I'm seeking my lordship's indulgence just to stay the only in regard of Lishami village. The other day I have placed before this honorable court, lordship, only in respect of Lishami village.
What is the impugn order?
Impugn order is, one is I have impugned 2. One is
8/4/2026.
One is annexure D27. This is the form issued by the state government. Where lordship, one
This is of dated 8/4/2026.
Yes, 8/4/2026.
And the other is dated
The other is
10/7/2026.
1 minute, lordship. One is 33, annexure F. This is the approval given by the Office of the Commissioner, Nagaland, Kohima. So since the village has village sent the selected members, this is unknown to the respondents. The act is. So without the knowledge of the respondents, the respondents has issued this page 36 lordship. There are 6 villages and it pertains, I'm confining only to serial number 6, Litsami village. Only this lordship. And lordship, now we are not on merit, how the clans have also submitted objection complaint to the head GB, that is Agkato village chief, the head of the village chief. The submissions are C1 also is there, submitted by the clans who were denied of their membership. Then there is interpretation copy. It is written in semi-dialect and interpretation is also there. So they submitted this to the respondents. Number 5. Number 5 is the head GB. That is, he is the head chief of the Litsami village.
Page number 36.
36.
And the name of the petitioner number 1 is at page at serial number 9.
Yes. Serial number 9. He is the petitioner number 1 because he knows that village chiefs are never inducted. This is the first time, even in my customary lordship, I being from my own community, this is first of its kind. Never can a village chiefs. They can never be, because they are ex-officio members with voting right. So they can never be village council members. And lordship, that I may forget, lordship will kindly allow me to rectify this paragraph 6 in my writ petition. One inadvertent rectification.
No, madam, you say there is one notification of the registry how to make correction.
Lordship.
You have to file one interlocutory application.
Lordship, just one name.
Maybe.
Clan.
You file one interlocutory application. On next date, we will allow you.
Okay.
No problem.
I shall do that.
Yes, madam, you are appearing for?
Yeah, Your Lordship, I'm appearing on behalf of the private respondent, number 5 to number 9.
Number 5 to number 9. Yes, Mr. Sanktam, you are for? You are not in this matter. Who is appearing for the state respondent?
Lordship, Mr. Mo, I am the other day also he knows it, but he was absent. Today also I called him up, he said that he is outside. So this is the second time, reason best known. He is not appearing. If he doesn't want to appear in this case, he ought to have. There are so many other advocates, but I don't know why. This is the second time. The other day also he knew it. In the morning he was here.
Okay.
And Lordship, respondent number, the other day I have already read out at page 29.
Not necessary to repeat the same.
Lordship.
Okay. Yes, madam, any submission?
Yes, Your Lordship, if I may be allowed to make my submission.
Yes.
Lordship, the petitioner's case proceeds on the misconception that 3 hereditary ex-official members were reflected as VCM in the form, that is Annexure D of your lordship may kindly peruse Annexure D. Your Honor, my submission is that the form is just merely it's just an administrative form. It's just a standard form, and that doesn't have the source of the legal sanctity, Your Honor. And the inadvertent description of VCM, the village council member, does not divert them of their independent statutory customary status as hereditary conference. Your Lordship, as the learned counsel has already pointed out in her, Your Lordship may kindly peruse the annex at page 19 of the annexure A. At section 4, it says that a village, Your Lordship, if I may be allowed to read the relevant portion.
Yes.
At para 4, membership. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government, provided that hereditary chief, GBs and ANG shall be ex-official members of such councils and shall have voting rights. So as I rightly stated, Your Honor, these four hereditary ex-official members, that in the standard form, it was inadvertently entered as BCM. However, that does not take away their statutory membership as given under the Village Council Act, Your Honor. And Lordship, the mere expression of the BCM, the mere use of expression BCM in relation to an ex-official member is that.
Madam, you see name and signature of newly elected village council members. Page number 27, Annexure D.
Inadvertently, four head village chiefs cannot be inducted, Lordship. Be it GB's village chief, be it VCM, it doesn't make any difference, Lordship. Whichever way, hereditary village chiefs,
Okay.
GBs cannot be.
Let her complete.
Yes. So, Your Honor, like this, the Lordship, the form is just a standard form only, and if it has inadvertently entered as VCM, that can be corrected. And Your Honor, if I may be allowed to submit my document, that is the newly amended Village Council Act, amended on 20 June 2022. This is at section 4. Section 4, Your Honor, like if I would be allowed to read out the relevant portion of the Act, it says that at Proviso A, the process of formation of the Village Council will get initiated with the issuance of a general notification by the government, and the entire process would be completed within the period given in the state notification, which shall not be more than 3 months. Every village so formed will continue for tenure, provided in case the new village being constituted during the so. Just the second paragraph, provided further that any dispute regarding the constitution of the village council or selection of any one of the member of the village council, the matter shall be referred to the state government, whose decision thereon shall be final. So, Your Honor, the maintainability of the present writ petition depends substantially on whether the petitioner has first invoked a statutory remedy that is given under the section 6A of the Nagaland Village Council and Tribal Act, and the petitioner has bypassed the statutory mechanism expressly prescribed under the proviso.
Maybe.
Yes,
Availability of alternative remedy always cannot be a bar in admitting this writ petition under Article 226. Some exceptions are there.
Lordship, here the Act says that it's not me, but it's specifically say that shall be referred to the state government, whose decisions thereon shall be final.
Maybe.
And the VCM that has been selected.
Okay, you do one thing, you file your affidavit
Your Honor, if I may be allowed, yes, Your Honor.
Will allow, but till then, this impugn order be stayed.
Your Honor, if I may be allowed to make just a few more submission.
Yes.
The result that has been selected as per the customary usages and practices of the Litsami village, and they've all been nominated by their respective clans. And these three hereditary Gamburas, I think they have already made a submission that the petitioner's signature was not there in the Form D, which was submitted in the Annexure D. However, the signature is not required because he is automatically an ex officio member of the village council. Therefore, his signature was not required. And during that meeting, the petitioner on that they have submitted in the application that as per the customary, the meeting was not conducted. However, Your Honor, if may kindly peruse at para 5, if I may just be allowed to read the relevant portion here, the petitioner has stated that the meeting was called at the resident of Akakau GB Hector's resident on 8/4/2026. So and so, the meeting was so and so, and in this, the petitioner number 1 was also present during the said meeting. However, Your Lordship, at para 6, the respondent is, the petitioner number 1 is contradicting his own statement, saying that no general public meeting was conducted. However, the names that have been forwarded to the authority is as per the prevailing customs and usages of the villages. Here, the Village Council Act, as per the Section 4, also has specifically said that the village it differs from, like the council has already submitted, it differs from tribe to tribe, from village to village. And this has been the long practices of the village council.
Okay, all right. You file your affidavit in opposition.
Your Honor, here the learned council has not submitted, the petitioner has not submitted that if the stay order is not granted, it will cause irreparable causes to him. Here, Your Honor, if stay is granted to the petitioner here, it will cause a lot of prejudice to the villages because the functioning of the village depends on the village council. And for the administrative purpose,
All right, you file your affidavit.
Yes, Lord.
Till filing your affidavit, we will stay the impugn orders.
Obliged.
Any other matter?
Yes.
That mentioned matter?
Yes, we haven't received a file yet.
Not received the file. Heard Ms. Zimomi, learned counsel for the petitioner, and Miss, your name please, madam?
Esther.
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 Esther, learned counsel for the respondent number 5 to 9. None appears for the respondent number 1 to 4. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 8/4/2026 for change of village council members by entering the name of respondent number 5 to 9 and submitting and submission of the same to the SDO Civil Soroboto subdivision as village council members, and also the order dated 26/7/2026 passed by Lithasami Blazers. Lithasami Blazers.
Yes.
And submitted to the subdivisional officer civil Soroboto, Zuneboto district, Nagaland. Ms. Zimomi, learned counsel for the petitioner, submits that the name of the petitioner number 1 is incorporated in the order dated 8 April 2026.
It's not order, Lordship. It's form issued by the state.
Okay, impugn form, in the form. form for change of list council members on 8th of April 2026 without the consent of the petitioner.
Lodge, number
Petitioner.
one.
And it was done with an ulterior motive to deprive other clans.
Yes, Lodge.
Other
That
clans.
is fine.
Other clans. And the same, no, and it is also in contrary to the section 4 of the Village and Tribal Council Act 1978. 78. And as such, she submits that the impugned form dated 8th of April 2026 and the resolution dated 26/7/2026 passed by the Litsami village may be stayed till returnable date. The learned counsel for the respondent number 5 to 9, however, vehemently oppose the petition. She submits that since statutory remedy is provided in the Act itself, this petition is not at all maintainable. Not at all maintainable. The submission of learned counsel for both the parties needs further consideration. At this stage, whether notice was issued, madam?
Yes, Lodge. I have served them dusty service and today.
No, whether formally notice was issued.
No, this is
No, there is one order for issuance of notice.
Notice was issued on 14th.
Yes, 49.
First order is on 14th.
Okay, the learned counsel for the respondent number 5 and 9 submits that she may be granted some time to file the counter affidavit. We are allowed to resist at least the matter. Resist at least the matter. After 2 weeks or 3 weeks?
2 weeks.
After 2 weeks. After 2 weeks. Still returnable letter. Till returnable letter. The impugned form numbers of form dated so and so and the order dated so and so stands the state.
In respect of Litsami, it might have
yes. In respect of
Litsami village.
Litsami village only. Okay.
Highly obliged.
Lordship, I have just been informed, but it's been I have not mentioned on the one. Lordship, I'm from Dimapur. I have not really conversed with the position. It's just from one member. I will file it tomorrow itself with a proper amendment and everything.
Tomorrow?
Yes, but tomorrow itself before. But in the interest of justice, kindly let the matter be heard today itself. It is only pointed on one member of making.
No, the matter is not before the court now.
Yes, the registries are seeking a permission of the court. It is only for entry number one, number which I missed out. Your Honor, the matter was written, drafted urgently last night itself only, since there is urgency in the matter. Otherwise, if the exam order is not ready.
Okay, inform them. Utilize the matter. No, madam, you asked the registry to send the file. Okay. Okay. Okay.